इसके बाद Lordship, my request is this document may be.
नहीं, ये सब
Your Lordship,
क्या डॉक्यूमेंट है?
that yesterday my Lord sir directed me to file.
टाइम से आगे फाइल किया
Lordship,
करिए।
what happened today in the morning? My petitioner's father was admitted in the hospital, so it was.
ले लीजिएगा।
IA number is there, but they have.
ठीक है।
Obliged sir. सर मेरा एक निवेदन और था सर कि खरे साहब 2 बार बहस कर चुके हैं, तो फिर और भी क्या जरूरत?
नहीं, उनको जो आपने कल कहा है
जी,
उसके लिए 10 मिनट में व्हाटएवर दे वांट टू से।
सर मेरा एक निवेदन और था सर कि कुछ बातें इनके टोकने के कारण छूट गई 2-3 बातें।
नहीं, ऐसा ये सब नहीं सब।
सर मेरा 2-3 लाइन का, मैं आई विल टेक ओनली 5 मिनट्स, आई मे बी हम्बली अलाउड। सर मेरा
मत करिए, समझ गए
क्या कि इन्होंने वो कर दिया तो मैं 2-3 चीजें भूल गया।
अरे नहीं, अच्छा वकील भूलता नहीं। आपने इतने बड़े 2 तो सिनॉप्सिस बनाकर दे दिए।
सर 2-3 जरूरी बातें बस रह गई है, मुझे 2 मिनट दे दीजिएगा, मेरा निवेदन है।
क्या बोलते हैं आप?
तो जैसा
सर आप कह रहे हैं तो मिल जाएगा सर, इनकी बात कर लूंगा, 2 मिनट ही लगेगा सर।
नहीं तो पहले बता दीजिए सो दैट दे कैन रिप्लाई टू इट। अच्छा
नहीं सर ये कर ले फिर सर।
हमें कोई आपत्ति नहीं, जो बोलना चाहे।
नहीं सर, हमें क्योंकि केस हमारा है। सर
नहीं, yesterday he argued at length. He rebutted each and every point raised by the High Court and the.
बहुत सी बात तो शुरू भी नहीं की थी, फर्स्ट टाइम।
इसीलिए तो आपने कल टाइम मांगा था, तभी तो हमने आपको टाइम दिया।
जी
पहले उन्होंने कम बहस की, कल 1.5 घंटा बहस की।
सर मैं सर
मुझे डर आज यही लग रहा है कि अगर आज अनुमति दे दी कहीं पूरा दिन फिर आज ना निकल जाए।
आप सर घड़ी देख के दे दीजिए, मैं 5 मिनट देकर दूंगा।
चलिए 5 मिनट बोलिए।
आप इनको कर लेने दीजिए पहले।
नहीं, पहले आप बोल लीजिए।
सर मेरा निवेदन ये था सर कि जो हाई कोर्ट ने पहले रिप्लाई दिया था सर, उसमें इन्होंने कहा था कि अगर ये कुछ वो कैंसिल कर देंगे, पर अभी दोबारा में बोला कि कोई रूल्स रेगुलेशन नहीं है, तो दोनों जवाब जो है सर आपस में वो कंट्राडिक्ट होते हैं।
I may be permitted to.
you'll have a chance. हाई कोर्ट के बारे में जो कुछ कहेंगे वो आपको कहने का मौका मिलेगा।
तो सर हमारा दूसरा निवेदन ये है कि सर जो इंदौर और ग्वालियर बेंच है, वहाँ पे जो हाई कोर्ट बार एसोसिएशन है,
आप पहले ही कह चुके, पहले दिन ही कह चुके हैं आपकी वहाँ पर एक बार एसोसिएशन है।
अब दूसरा सर एक इस दौरान जो पिटीशन की पेंडिंग रहने के दौरान ओबीसी वेलफेयर एसोसिएशन ने भी एक डॉक्यूमेंट मतलब सीजे साहब को दिया था कि हमको भी एक जगह दी जाए
जी।
वो हमने डॉक्यूमेंट लगाया था और वो हालांकि लिया नहीं गया, पर रिकॉर्ड में है सर।
नहीं, लिया नहीं गया रिकॉर्ड में।
मतलब हमारा ये निवेदन है कि अगर ये पिटीशन अगर इनको अगर जगह दी जाती है तो और भी लोग इनकरेज होते हैं इसके कारण।
ठीक है, वो तो कल आप बता चुके, कल आप बहस कर चुके।
मैंने अपनी प्लीडिंग में लिखा था 3.14 में कि ये प्राइवेट क्लब है, तो इनको हमारे बोलने
कल नहीं देखिए
सर एक मिनट
नहीं, आपकी प्लीडिंग है एक।
और मैंने
आपसे कल रिक्वेस्ट किया था कि जब आप PIL में चीफ साहब के यहाँ खड़े होते थे, हम लोग वकील थे, हम आपको देखते थे। Those were different days. There you were appearing as a civilian.
जी सर जी।
Today you are appearing as a lawyer. So you are required to follow the discipline which a lawyer is required to follow. ठीक है? If you want to give up the attire of a lawyer, you come as a civilian. I'll give you a wider latitude to speak, because civilian we understand has, because of lack of knowledge about the court procedures, cannot be bound in terms which we try to bound a lawyer, because we understand that lawyers have a deep understanding of the procedure which is to be followed in the court and the etiquettes which are to be observed. So I'll not permit you. You may call them anything. That is your personal affair. But as far as on date, they are a High Court Advocates Bar Association and they are to be addressed by that name.
Your Lordship, हमारा यही निवेदन था कि हमने उसमें लिखा था, इन्होंने पैरावाई जवाब में उसको कुछ भी काउंटर नहीं
किया। वो तो कल बता दिया आपने कुछ नई बात नहीं कह रहे हैं आप।
जो बीडी कौशिक में जो मैं
कोई आपको देख रहा है क्या वीडियो से?
नहीं सर।
अच्छा, तो ऐसी बहस मत करिए जो कि दिखाने वाली होती है।
किसी को नहीं दिखाना सर।
बस, सही
आपने तो
point-
वीडियो बंद करा दिया।
सही पॉइंट बताइए, चलिए।
सर जो बीडी कौशिक में एक पॉइंट था जो मेरे काम का सर,
हाँ।
मैं वो बता देना चाहता हूँ।
हाँ।
मैं जो पढ़ दूं सर एक
क्या है वीडियो क्वेश्चन में, बताइए ना,
सर
क्या पॉइंट है?
इसमें जो पेज नंबर जो 12 है उसमें मेरे काम की चीज लिखी है सर, मैं उसी को पढ़ना चाहता
हाँ,
हूँ।
बताइए।
सर आफ्टर ऑल bar association in a court informed for the purpose of seeing that all lawyers practicing normally and regularly in this court that court under one umbrella.
वो पहले दिन आप हाईलाइट करा चुके हैं। आई हैव ऑलरेडी नोटेड इट, आई हैव ऑलरेडी नोटेड इट। चलिए और बताइए। पैरा 12 है ये
सर मेरे पेज 12 में है सर।
आपके पेज 12 से थोड़ा
और पेज नंबर सॉरी पैरा 23 में है
एससीसी का।
ये सर मनुपत्रा से
मनुपत्र नहीं होता है
सर, ये मैं दे देता हूँ सर।
नहीं, आई कैन नॉट हैव, वी कैन नॉट हैव cases of cross referencing.
Your Lordship,
Standard is SCC, you refer to SCC, produce SCC citations.
Your Lordship, हमारा यही कहना है कि माननीय सुप्रीम कोर्ट ने कहा है कि सभी वकील जो है एक ही अम्ब्रेला में आते हैं, उनका एक ही इंटरेस्ट होना चाहिए, अलग अलग उनको अपना अपना वो नहीं करना।
ठीक है,
बस हम बस यही हमारा कहने का रह गया था सर।
ठीक है।
और सर जो मनोहर ममतानी साहब का जो मैंने
कल बता चुके
वो सर वो बिजली वाले में बताया था, पर इसमें हमारा ये उस एक काम की चीज लिखी है कि उन्होंने डिस्ट्रिक्ट कोर्ट्स को लिखा है कि एक की कोर्ट के अंदर एक ही चैम्बर होना चाहिए और सभी एक ही जगह बैठेंगे।
ठीक,
तो ये कंटेंशन भी सर
कहाँ लिखा उसमें सभी एक ही जगह बैठेंगे?
सर एक पैरा में है सर, एक चैम्बर में बैठे।
पढ़िएगा वो पैरा पढ़िएगा
सर। ये 18 पैरा, 1 person 1 chamber 1 court complex।
कहाँ लिखा है?
ये सर
मनोहर ममतानी साहब के उस ऑर्डर में जो आपने कल पेश किया 2016 का
18 पैरा 18 में सर
दीजिएगा भाई।
ये ले लीजिए सर।
नहीं इसमें रखा हुआ है, दीजिए। कल दिया था ना उन्होंने मनोहर ममतानी साहब का ऑर्डर, कहा था कि हमने कहा था जजमेंट नहीं है, ऑर्डर है, कहा था टेकन ऑन रिकॉर्ड। दिखाइए भाई, ये ऊपर खोलिए तो फाइल तो खोलने की, ये नहीं, ये खोलिए, ये कागज क्या है? ये नहीं, मनोहर ममतानी साहब का ऑर्डर है, सर्कुलर ऑर्डर। कल दिया था रखने के लिए, ऐसे कहाँ चला गया? कैसे घुसे हुए कागज? ये कैसे मुड़ा हुआ कागज रखा है? प्लीज प्लीज
सर पैरा 18 में है सर, 3rd पेज में।
हाँ।
और ये 19/12/16 का डॉक्यूमेंट है सर।
ठीक है, चलिए
जी। सर सायरा बानो का एससीसी नंबर नहीं दे पाया था मैं।
कल दे दिया था आपने?
नहीं सर, नहीं दिया था।
तो बताइए सायरा।
2017 9 SCC 1 सर।
2017
9 SCC 1।
ठीक।
ओब्लाइज सर।
हाँ मिश्रा साहब, आप कुछ कहेंगे? इन्होंने सिर्फ एक पॉइंट कहा है
जी सर,
कि पहले आपका स्टैंड ये था
जी सर,
कि जो नियमानुकूल होगा वो किया जाएगा।
जी सर।
बाद में आपने कहा कि
नियम है ही नहीं।
नियम है ही नहीं।
जी सर।
उसके बारे में क्या कहना है आपका?
Like you have submitted earlier that the allotment is in the nature of a license. It is in the nature of a license. Lord, they had submitted an application. Lord, they had submitted an application requesting that the premises should be, they are a body of advocates, association of advocates, and therefore they require a place to function from. In that application, it was submitted.
तो लाइसेंस पे देने के लिए कोई प्रक्रिया है? वो आपने कल कह दिया नहीं है।
Sir, प्रक्रिया नहीं है।
नहीं है।
So therefore, not when there are no statutory rules or regulations defining the.
अंदर रखिएगा जी।
So, my submission is humble submission is that when there are no regulations or rules defining the procedures, then not the inherent powers come into play. And what has to be then observed is not whether the inherent powers have been so exercised and would render that exercise to be irrational, illegal, irregular, or qualified notes. So these are the only grounds not if there are inherent powers now, then because here not there is no, admittedly there is no relation, we have filed the reply affidavit as your lordship directed.
ठीक है.
So therefore not those inherent powers have been exercised, and my lord will have to then examine the propriety of the action in the context of not whether they are irrational, irregular, illegal or malified. अब malified का allegation कोई ने लगाया नहीं है सर. Otherwise probably they would have to not do the necessary legal formalities also. It's a very general petition that they are not being permitted. This has been wrongly allotted, etc., etc. And like learned senior counsel Mr. Kharem Lodi argued that the reliefs also are contradictory.
वो तो कल हो गया है.
जी सर. मतलब they want the cake and want to have it too. That is the not some substance how can put it not. इनको वो स्पेस का वेकेशन भी चाहिए और इनको इन द अल्टरनेटिव उसमें एक्सेस भी चाहिए. So they must decide what they want. There is ambiguity on their side also.
जी, ठीक है, वो तो कल बता दिया सर.
One thing, and one citation I would like to refer. This is regarding an advocate who filed a public interest litigation before the Nagpur High Court, and Lord, that petition was.
भैया आप इनके बात का जवाब दे रहे हैं, साइटेशन कहाँ से
सर ये वो कल जो दिए थे उसी के उसमें एक छूट गया था, तो इसको प्लीज नोट कर लिया जाए.
जी.
So this Lord, he was a Lord. This is 2005 Volume 1 ACC 590.
क्या कहता है?
Lord, this was the case note where an advocate had filed a public interest litigation in the Nagpur High Court,
जी.
and that petition was dismissed on the ground that it was for oblique motives. Cost of 25,000 was imposed, and eventually, Lord, the matter went up to Bombay High Court, and from there, Supreme Court, Lord, has this judgment. In fact, it's a very short judgment, but it is entirely on the maintainability of the PIL.
Right. ठीक है.
And what they say, Lord, that in para 20,
Yes.
that they would have considered in this case they would have considered imposing exemplary cost, but for the fact that the High Court had already imposed 25,000 rupees cost. The conduct is therefore very important, Lords. Here in the present case, Lords, the petitioner, Lord, he has filed the petition as though, Lord, he is trying to forward the cause of the MPSCBA. But MPSCBA, Lord, is not coming forward. They could have filed a petition supporting the petitioner, but that is not so. So therefore, my submission, Lord, here, when a petition by a counsel is filed for oblique motives, then that has to be dealt on a different footing. That is all.
सर ये नोट कर लूं मैं एससीसी में सर.
हाँ, क्यों आपको नोट करने से किसने मना किया?
और सर एफिडेविट में कोई कॉन्ट्रडिक्टरी स्टैंड नहीं है सर, जैसा इनका कहना है. वी हैव ओनली लॉर्डशिप हैज sought a clarification. We have given that. Earlier also we said that there is a license.
कल हो गया है.
No, because he has just made the submission.
आपका हाई कोर्ट का किया था इसलिए नोट कर लिया.
सर,
Nothing beyond it. Like, sorry.
इन्होंने ये
इस तरीके से बहस नहीं होगी.
जी सर.
इस तरीके से बहस नहीं होगी.
Oblige sir.
There has to be some discipline.
Your lords.
Yes.
So I'm trying to maintain a discipline only, if my lord permits me, because whatever has been cited by him. Just a small answer in 2 minutes, that's all.
जी.
Not beyond that. Sir, the allotment is not a malified. Whatever judgments have been cited, they are in a shape that this has been a largesse by the government or by the authorities. The Honorable Chief Justice has not thrown a largesse upon the Bar Association by the allotment. This is neither a malified transaction. It is not a transaction. It's an allotment when the need arose, an application was made, and therefore the allotment was made. Secondly, B.D. Kaushik has been cited, my lord. B.D. Kaushik, I'll not even read it. I'll only say para 49 and para 80 of the judgment may kindly be seen. It doesn't say that only one bar can be there. There can be several bar. Only the right.
कल आपने बता दिया.
नहीं, वो para
उस पर्पस के लिए.
स्पेसिफिकली para 49 और para 80 बस मैं बता रहा हूँ.
ठीक है.
मैं ये नहीं कह रहा हूँ आप मैं पढ़ के सुनाऊंगा. मैं सिर्फ ये बता रहा हूँ. क्यों इन्होंने बहुत लंबी चौड़ी बहस करी थी, इसलिए वो हालांकि आंसर हम लोग नहीं कर पाए, समय हो गया था. वी डिड नॉट. द शॉर्ट आंसर टू दिस इज ऑल दोस जजमेंट्स आर नॉट एप्लीकेबल ओवर हियर.
ठीक.
राइट.
Lord, I have
10
prepared
minutes for yesterday's case and then.
Lord, some of my submissions, Lord, the interconnected, interrelated, inseparable.
नहीं.
Lord, inseparable है. As per the bar matter also, Lord, as per the recognition matter, and Lord, the allotment of space.
अपन दो पार्ट में अलग-अलग चलेंगे.
सर वो दोनों कॉमन ही हो जाएगा सर, उसमें टाइम बचेगा.
नहीं मेरी रिक्वेस्ट.
सर उसमें टाइम बच जाएगा सर. और for just not to facilitate not the fast hearing of the matter, Lord, I placed a small note which is nothing beyond the pleadings or the documents on record, my lord. Everything is not based on the record. एक वहां भी दे दो, पीछे सबको दे दो, विदेश में।
ये दोनों केस का कंबाइंड है।
Yes, Lord.
जी।
Lord, if your lordship would see the page 1, in 2006, the Petitioner Bar Association was registered under the MP Society Registration Adhiniyam. Not 26/9/2008, my lord. The inauguration of the bar room was made by the then Chief Justice of the High Court, Shri A.K. Patna High Court. The photographs and the inaugural stone are part of the record. On 14/11/2009, the inauguration of the library by the then Chief Justice of India.
Names are not relevant.
Yes, Lord.
Names are not.
Very well, Lord. Very well. In presence of other Supreme Court judges as also the Honorable Chief Justice of the High Court and also Honorable Judges of the High Court as also the Advocate General.
Ji.
There was inauguration of a library, my lord.
Ji.
On 8/4/2011, my lord, there was inauguration of conference rooms of the Petitioner Bar Association by the then administrative judge of the MP High Court.
Ji.
On 30th of April 2016, my lord, e-library was donated by, my lord, by the very eminent retired judge of this High Court, my lord, and the same was inaugurated, my lord, by the then Chief Justice, my lord, in presence of other honorable judges of the High Court, my lord.
Ji.
Now, my lord, in 2017, additional adjoining space was allotted to the Bar Association by the then Honorable Chief Justice, my lord.
Where is that allotment order?
My lord, allotment order, my lord, allotment order is a part of the record of the High Court, my lord, but my lord, the inaugural stone is there, my lord. Inaugural stone is there.
Inaugural stone is not the allotment order.
My lord,
It is the
Lord,
it is the order
and
of
the
allotment.
Honorable Chief Justice who made an allotment, my lord, he himself inaugurated the new Bar Association.
Mr. Sanjay Agarwal, that will not help you. Once you say
Yes, Lord.
additional adjoining
allotment
space was
Yes,
allotted to the Bar Association.
It was possession was delivered to us, Lord.
Where is the allotment order?
Lord, officially we are not having it, but it was officially we were given delivered
So we
possession, Lord.
write
It's a
no
part of the record.
No official allotment letter. Mr. Mishra, you will respond to it. You please.
Yeah, एक मिनट है बताओ additional एक मिनट just verify the fact call. मतलब Mr. Praveen ji would verify.
Yes.
Then, my lord,
No, we are talking about 2017 order which they are saying
Well,
that additional space was allotted. No official communication order.
Lord, we'll see to it.
Ji.
Now, on 11/12/2017, the inauguration of the new bar room, my lord, with the additional adjoining space was inaugurated by the then Chief Minister of the state, my lord,
Ji.
as also, my lord, the Chief Justice of the High Court, my lord.
Ji.
So, my lord, this is the history, my lord. Time to time, the allotments were made and the same were inaugurated, my lord, by the high dignitaries, my lord, as mentioned herein, my lord.
Yes.
Then, my lord, if your lordship would turn to the next page,
The infrastructure which is available is.
now, the facilities and the infrastructure provided by the Petitioner Bar Association in the space allotted to it, Lord.
Yes, yes.
Well furnished air conditioned bar room.
ठीक है, there is no need to read.
Plot by submission is not. Kindly. Well equipped air conditioned library with proper designated reading space.
We'll go through.
Well equipped air conditioned e-library, my lord.
Mr. Agrawal,
Yes, Lord.
we are aware of this fact that it is one of the best. Yesterday you said
Yes.
it is one of the best bar rooms in the country.
Yes, Lord.
So all this
Very well,
infrastructure, why waste time on
Very-
that?
very well.
We understand that.
Yes, Lord. Now, Lord, I'll come down straight away. I'll come down to the serial number 7, Lord. Now, for providing, Lord, the state-of-the-art facilities
Ji.
in the space allotted to us, Lord,
Ji.
we have spent lakhs and lakhs of rupees
Ji.
over the period of time, and the entire fund, my lord, was generated generated from the members of the association, my lord. Now, my lord, from 2006, now we are in 2024. 18 long years have passed. Now, in such a long period, my lord, we have been able to develop, Lord, and as an acclaimed institution of the country, my lord. Then, my lord, now the
How much amount has been spent?
Yes, my lord. But over the period of lakhs and lakhs of rupees, my lord. Up exact amount, my lord, it would be. Not we may have spent more than 40-50 lakhs of rupees over the period of time, my lord.
There must be books of accounts.
Books of accounts showing some of the infrastructure speaks for itself.
Okay.
But the infrastructure, not which we have created over the period of time,
Books
it
of
speaks for
accounts है क्या?
itself.
Books of accounts है क्या?
Books of accounts.
Record पर है कि नहीं है?
Audit होता सर हम लोग का साहब.
अरे वो अलग चीज है.
Audited account है हम लोग.
अच्छा ठीक है.
Yes. Now, my lord, the petitioner, my lord, the PIL petitioner has only raised 2 grounds
जी.
on the basis of which we are sought to be uprooted from the place or the space which has been allotted to us. So the 2 twin grounds are, my lord, number 1, my lord, that it is not a recognized bar association from the State Bar Council. Number one. Number two, my lord, that no bidding process was made by the High Court at the time of allotment of space to the petitioner bar association. But if you lordship would see the entire petition, only two grounds are made out.
Yes.
Now the third one. Now, my lord, we have already addressed, my lord, while we were arguing a recognition matter, my lord, that to exist or subsist as a bar association, we don't read and need any recognition from the State Bar Council. What is needed is a recognition from the High Court itself. And that we have. Now, I will further proceed not how we have the recognition.
You are giving up your challenge to the
No, we
orders
are not
of the
giving
Bar
up the
Council?
challenge. No.
You-
To exist as a bar association, we don't need any recognition from the bar. Without there being any recognition from the State Bar Council under the 2015 rules and 82 Adhiniyam, we can exist as a bar association, Lord. That is for a limited purpose, Lord. Then, Lord, the allotment orders were issued by successive Chief Justices and are unassailable, and such allotment orders, Lord, are unassailable. That is my submission, Lord, and cannot be a subject matter of judicial review, Lord. Not the Chief Justice, not the administrative head of the High Court. Successive Chief Justices have made allotments from time to time, Lord. So those allotment orders, Lord, cannot be assailed at the instance of a PIL petitioner, Lord. And all those allotments were made in exercise of the administrative power by the Chief Justices, my lord. That is my submission, my lord. It cannot be a subject matter of judicial review at all. No specific rules and regulations are required. But these decisions were taken, my lord, by the then Chief Justices, my lord, on the administrative side. And therefore, they cannot be a subject matter of challenge in the jurisdiction, my lord. Then, my lord, if your lordship would turn to page 4.
Just a minute. Page
Yes.
4. Yes.
Then, if your lordship would turn to page 4, from time to time we have been organizing law lectures, my lord, and the top dignitaries of the country, my lord, the legal luminaries were called, and they presided over the function, my lord. They delivered their lectures, my lord, in such functions organized by the Petitioner Bar Association. Now, on 14/11/2009, we had started, not in fact, a law series. The first law lecture was organized, in which the then Chief Justice of India, my lord, was the chief guest.
Yes.
And other Supreme Court judges, 4 other Supreme Court judges, my lord, were the guest of honor, my lord. All, my lord, in that function, my lord, all the judges of the MP High Court, my lord, including the judges of Indore and Gwalior, had attended the law lecture. Then, what 20th of November 2020, the another law lecture was organized, in which, my lord, the so and so, my lord, judges I have named, my lord, they had participated in the function and they had delivered lectures, my lord. In 2011, my lord, again a law lecture was organized. The former Chief Justice of India had delivered a law lecture. In 2012, my lord, the then Supreme Court Judge, my lord, had delivered a law lecture, my lord. On 17/8/2014, fifth law lecture was organized, in which Honorable so and so, my lord, Justice of Supreme Court was the chief guest, and Honorable so and so, my lord, presided over the function, my lord. Then 2017, my lord, the then Honorable Chief Justice of India, my lord, was felicitated by the Bar Association. Now, all these functions, my lord, have taken place, were organized either in the Oval Lawn of the High Court or in the conference hall, which is known as South Hall Block, South Block. Not,
Sorry. Please continue.
yes, not the Petitioner Bar Association, not on regular basis, organizing various functions from time to time, and are inviting not the dignitaries, not on the judges of the court, and they are attending not the function. Not today itself, not we had a high tea, and we had invited 2 senior most judges of the High Court in our bar room, my lord, and they had come for a high tea, my lord. Then, my lord, all the events, but what the aforesaid events, but would indicate.
मेरे ख्याल से इसको मेंशन नहीं करना चाहिए था आपको. Because inviting somebody for a high tea may be a personal affair of the association, and that cannot be a source of influence on the bench. I think that you should be
Very
more
well.
discreet while
Well, I'll escape
arguments.
that. Then, my lord, all the events would indicate, my lord,
And that may prompt us from not coming to your functions in future if we are invited.
Lord,
because that may be cited as a
Lord, we are
precedent
a
before
court
the
annexed bar association, more than on regular course of law, such interactions take place. my lord.
Any interaction is good.
Interactions take place.
We are two wheels of the same.
Yes, my lord. That is what the BD Kaushik says, my
That
lord.
is that is
Para
not,
28,
that is,
my lord.
that is not in dispute.
Very well.
We recognize this fact. We respect this fact that without you and your assistance, we are nothing. But at the same time, if I come to your son's marriage
Lord, we
function,
invite each other, my lord.
that cannot be
Lord,
cited
we
as
are invited by our lordships, my lord.
That's
With
all.
each other, my lord.
That's all. That's all. That's all.
Yes, my lord. So, my lord, my submission is, my lord, all these events would indicate, my lord, that we are the recognized court annexed bar association, my lord, and this fact cannot be disputed, my lord, and we have been able to justify the allotment of a space to us, my lord.
Yes.
Then, my lord, if a lordship would see the another next page, my lord, that we are, my lord, the Petitioner Bar Association is officially invited in all the official functions organized by the High Court. The President of the Association addresses in the ovation of the farewell ceremonies and other functions of the events organized by the High Court. The President of the Petitioner Bar Association is an ex officio member of the High Court Rule Making Committee, my lord. But this is on the public website, official website of the High Court. But I have enclosed those screenshot lot which are available on the public of the official website. And the President of the Petitioner Bar Association is a member of the Apex Committee for redressal of grievance of litigants and members of Bar Association as per scheme notified by the High Court order dated so and so. Now these two, my lords, information which is available on the website, we have enclosed as A1 and A2, my lord. If a lordship would turn to the next page, my lord.
A1.
A1, my lord. High Court Rules Making Committee, my lord.
Ji.
If a lordship would see the serial number, my lord, 9, my lord.
Ji.
The President High Court Advocate Bar Association Jabalpur ex officio, my lord.
Ji.
Then, lord, they turn the next page, my lord. Serial number 6, my lord.
Yes. Yes.
So, my lord, all these recognition, my lord, are flowing from the administrative side of the High Court, my lord.
Ji. Mr. Mishra, please take note of all these things. You will be required to answer them. They say that High Court has given them official recognition by making them part of the Apex Committee for redressal of grievance of litigants and members of Bar Association. So also by making them part of this High Court Rules Committee, Rule Making Committee. So they have an official recognition now, and that cannot be withdrawn by the High Court.
So the private notes, then only I will be able to respond. Because I cannot respond to the instruction. Not my friends have the instruction straight away. For me, it is a very difficult question.
So I'll frame these questions and grant you time to, yes. Then you file affidavit of the Registrar General. Yes.
So, my lord, all this, my lord, validates, my lord, and the allotment of a space to us, my lord.
Ji.
And that such a facility, my lord, which was extended to us, my lord, cannot be withdrawn, my lord.
Ji.
Now, my lord, it was argued, my lord, that the bidding process had not taken place at the time of allotment of a space to us, my lord. And Lord, he has referred to the Bhokta Congress judgment, plot and the several other judgments which are on the same line.
Ji.
But those judgments have no application at all.
Ji.
It is not a distribution of a state largesse.
Ji.
The space was not allotted to us, Lord, for any commercial purpose.
Ji.
Everywhere throughout the country, Lord, these spaces are allotted. This is in fact a facility given to us to a court annexed bar association, my lord. And for which, Lord, bidding process, Lord, never takes place. Such a space cannot be allotted to anybody else except a court annexed bar association, my lord. Yes, Lord. So, my Lord, the High Court Advocates Bar Association, my Lord, it a part and parcel of an administration of justice, my Lord. And being a part and parcel of an administration of justice, my Lord, these facilities were provided to us. ये है सर अलॉटमेंट है 2017 का ये तो कॉपी है ये है अलॉटमेंट है ये प्रवीण जी ओरिजिनल आप रख ले कॉपी पर Now, it reads with the Honorable Chief Justice is pleased to allot the room in the first floor of the old administrative block presently occupied by the Supreme Court section to the High Court Advocate Bar Association. Lord, by order of Honorable the Chief Justice, Lord, the registrar, they had signed it, Lord. And this was addressed to us, Lord, to the President and the Secretary, Lord, and to other dignitaries, Lord, as mentioned therein, Lord. So, my Lord, all these allotment orders have been passed by, Lord, by the successive Chief Justices, Lord, in exercise of their administrative power and being the administrative head of the High Court.
Yes.
So, my Lord, I have demonstrated, my Lord, the allotment from time to time, my Lord, the facilities which we have provided, my Lord. All the inaugural stones, my Lord, are part of the our rejoinder, my Lord.
Right.
The law lectures which we have organized, my Lord, is a part of the rejoinder. We have filed various invitation cards along with the rejoinder.
That
Yes.
is not disputed.
Yes, but all these are undisputed facts and emerge from the record of the case, my Lord. My Lord, A1, A2, my Lord, I have demonstrated, my Lord.
Yes.
Now, my Lord, I refer to a recent judgment of the Supreme Court, my Lord.
Yes.
ये ली, उधर भी दे दो. Not here, my Lord, what had happened. 1.33 acres of land, which was near to the Supreme Court, my Lord, was allotted not by the government to the Supreme Court. The Supreme Court Bar Association, my Lord, wanted the entire land to it for construction of lawyers' chambers, my Lord. And for that purpose, my Lord, the petition was SLP was filed in the Supreme Court. The Bar Council of India had also staked its claim. They wanted to construct a new building, my Lord. Supreme Court on record, my Lord, advocates, SCORA, my Lord, the Supreme Court Advocates on Record Association, were also staking claim on such land, my Lord. Now, my Lord, if your Lordship would see the paragraph 9, my Lord. Lord, the relief clause is also quoted here, my Lord. If your Lordship would the first page, my Lord, the relief clause is quoted, my Lord. Then, my Lord, the contention of the various parties, my Lord, and paragraph 9, my Lord, Mr. R. Venkat Ramani, learned Attorney General, appeared on behalf of the Union Government. The Attorney General has submitted that the issue should be taken up on the administrative side by the Supreme Court, and that in his own capacity, he will facilitate an attempt to secure the needs of institution and of its stakeholders. The Bar Association is one of the important stakeholders, my Lord. Then, my Lord, the submissions have been again recorded, my Lord. Then I will come down, my Lord, to paragraph 14, my Lord.
Yes.
During the course of the deliberations at the oral hearing, the bench has indicated that it is fully cognizant of the needs of the lawyers appearing before the Supreme Court, who are vital stakeholders in the administration of justice. Moreover, it was also noted during the course of the dialogue that the litigants are stakeholders as well, and while creating or upgrading the existing amenities, the interest and welfare of litigants has to be duly recognized and protected. The narration of submissions would indicate that while Mr. Vikas Singh, learned senior counsel appearing on behalf of SCBA, has sought a resolution of the demand raised in the petition on the judicial side, SCORA and the Bar Council of India, on the other hand, indicated that they would wish to have the issue addressed on the administrative side so that an appropriate view can be taken by this court administratively after deliberations with their representatives. There is no gainsaying in the fact that the members of the bar, together with the litigants, have an important role in the functioning of the judicial institution of the Supreme Court. During the course of hearing, we have abundantly indicated to the learned senior counsel that the views of the bar would be solicited and deliberations will take place on the administrative side with the members of the associations and the bar council. The learned Attorney General for India has, in the same manner as SCORA and the Bar Council of India, indicated that the issue needs to be taken up on the administrative side and not on the judicial side. We are categorically of the view that it would not be appropriate to entertain a petition Article 32 of the Constitution seeking a direction that the entirety of the land measuring 1.33 acres should be allotted for the construction of a chamber block for lawyers. On 27th August 2018, the Additional Registrar of the Supreme Court of India addressed a communication to the Honorary Secretary of the SCBA stating that 0.50 acres out of so-and-so of land shall be earmarked for the construction of lawyers' chambers subject to a change of land use by the concerned authority. Mr. Vikas England, Senior Counsel appearing for the SCB, urged that the direction for the change of land use has to be adjudicated only on the judicial side. However, this may not be a correct perception. Issues pertaining to the change of land use as indicated in letter dated so-and-so are eminently suitable for being addressed on the administrative side. SCBA cannot assert a right to the entirety of the land measuring 1.33 acres which has been allotted by the Union government for housing the Supreme Court archives for converting it into a chamber block for lawyers. The Supreme Court of India discharges both judicial and administrative functions. The discharge of its functions implicates diverse stakeholders including lawyers, litigants and the staff engaged in activities of the Supreme Court. A holistic view has to be taken on the allocation of available resources by balancing the needs of stakeholders both for the present and the future. These are matters which cannot be resolved by the application of judicial standards and have to be taken up on the administrative side of the Supreme Court. Administrative functioning and decision making, which the current issue requires, cannot be moved to the judicial side. So, my lord, then, my lord, apart from the lawyers, which seeks the conversion of the entirety of the land at measuring so-and-so to a chamber block for lawyers, the petitioners have also sought the conversion of the entire area around Supreme Court as a Supreme Court block so that all buildings across the Supreme Court on Bhagwan Das Road can be utilized for conversion to lawyers' chambers. The petitioner has also sought the allotment of a government bungalow presently occupied by the Foreign Correspondents Club to the petitioner. Such directions cannot be issued on the judicial side. We therefore are unable to subscribe to the reliefs which have been sought in the petition Article 32. However, we leave it open to the Supreme Court of India on its administrative side to take appropriate decisions, bearing in mind the needs of the institution for the present and the future and the interest of all stakeholders. The process of decision making would also involve consultation with BAR, SCORA, SCB and BCI would be at liberty to address the issue with their representations on the administrative side. The writ petition shall accordingly stand disposed of so-and-so, so-and-so. So, my lord, Supreme Court, my lord, declined to interfere, my lord, under Article 32, my lord, as regards its allotment of space to us, my lord. Here, my lord, the allotment of space has already been made. More than 16 years have passed. Now, that allotment cannot be cancelled. A right has been created to us, a valuable right was created to us, substantial amount has been invested, state-of-the-art facilities have been developed, we have been able to develop and grow, my lord, as an institution, as an acclaimed institution of the country, my lord. Now we are sought to be uprooted at the instance of the PIL petitioner, my lord. Can he be said, but can this petitioner be said to espousing the cause of public at large? Yes. My lord, the allotment orders made on the administrative side cannot be tested on the judicial side, my lord. That is my submission, my lord. Very specific submission. Yes, bro. So, my lord, the allotment cannot be made on the judicial side, my lord, which is what the Supreme Court says, my lord. It can only be done on the administrative side, my lord. Here, my lord, it has already been done on the administrative side, my lord. Therefore, the same cannot be a subject matter of challenge in the writ petition, my lord.
Right.
Then, my lord, my lord, the cost of repetition, my lord, I am only referring to para 8 to para 20 of the BD Kaushik judgment, my lord. If your lordship permits, my lord.
Please, please, please.
Yes, my lord.
BD Kaushik, please. Para 28.
Yes, my lord.
Please.
There is no manner of doubt that court annexed bar associations constitute a separate class different from other lawyers associations such as Lawyers Forum, All India Advocates Association, etc., as they are always recognized by the court concerned. Court annexed bar associations function as part of the machinery for the administration of justice. As is said often, the bench and the bar are like two wheels of a chariot, and one cannot function without the other. The court annexed bar associations start with the name of the court as part of the name of the bar association concerned. That is why we have the Supreme Court Bar Association, Tis Hazari District Court Bar Association, etc. The very nature of such a bar association necessarily means and implies that it is an association representing members regularly practicing in the court and responsible for proper conduct of its members in the court and for ensuring proper assistance to the court. In consideration thereof, the court provides a space for office of the association, library, and all necessary facilities like chambers at concessional rates for members regularly practicing in the court, parking place, and canteen besides several other amenities. In the functions organized by the court and its bar associations, the judges participate and exchange views and ascertain the problems, if any, to solve them and vice versa. There is thus regular interaction between the members of the bar association and the judges. The regular practitioners are treated as officers of the court and are shown due consideration. Then, my lord, para 49, my lord, my learned friend of the senior Mr. Khare has also referred to, my lord. This only deals with the right to form an association, my lord, under Article 19(1)(c) of the Constitution, my lord. Then I will refer to paragraph 8.
Paragraph 80.
80. Eight. Yeah, yes. This court has considered the request made by the learned counsel appearing in the matter to give appropriate directions of the guidelines for effective implementation of one bar, one vote principle enunciated by the amended rule. It is a matter of common knowledge that this court has provided 4 huge libraries, 3 canteens, 2 lounges, several rooms to be used as consultation rooms where learned advocates regularly practicing in this court can consult with their clients, arbitration rooms, advocates, chambers, huge parking places, free use of electricity supply, etc. to the members of SCBA. It is not in dispute that there are about 10,000 members of SCBA at present, though the actual number of advocates of the practitioners who are regularly practicing in this court is not more than 2,500, out of which there are about 900 advocates on record.
Ji.
Yes, my lord. Then, my lord, I had already referred, my lord, to 2 judgments, my lord, of the Madras High Court, my lord.
Yes.
Where, my lord, recognition was given to another bar association also. The bar association was already existing. The another bar was also constituted, my lord, to which was recognition.
जो बार काउंसिल वाला जो केस है, उस केस में ये 2 जजमेंट्स रखे हुए आपने दिए थे पिछली बार, गोभी चेट्टा पलायम और मद्रास हाई कोर्ट बार एसोसिएशन, जो उस फाइल में रखे हुए हैं, जिसमें आपने बार काउंसिल के एक्ट को चैलेंज किया है, उसी में दिया था ना?
हाँ, उसी में दिया।
हाँ, उसमें देखिएगा, कल नहीं दिए थे, पहली बार जब बहस हुई थी तब दिया था आपने, हैं? अरे 20/2 को बिजली वाली फाइल रखी है, आपकी फाइल थोड़ा ना लगी है 20/2 को, आपकी फाइल तो आज ही लगी है। बिजली वाली फाइल 20 लोगों को लगी है।
उसका केस नंबर सर बता।
7551/16।
यस
7551/16 में देखिए। स्पेयर कॉपी है क्या बाई चांस?
एक्स्ट्रा कॉपी। ये वो ये दो कॉपी। ये दो
कोई बात नहीं, हम एक से
नहीं है सर।
Yes, sir, I have.
दो कॉपीज।
इनको सबको संभाल के रखिए भाई, सब में मार्क करके फिर दिखाते लोग दिक्कत आएगी। इस गोभी चिट्टा पलायम।
Yes, Lord. This is Lord.
You
This is of 2012 of the Madras High Court.
Yes, yes.
Paragraphs 3 and 4, my Lord.
Yes.
As per the affidavit in support of the writ petition, the members of the petition association were originally the members of Gopi Chetty Palayam Bar Association.
Now I recollect.
Yes, Lord.
Yes. Some members were thrown out, they were not allowed. That was the background.
That was the background. They formed a new bar association. They applied for recognition, and the same was granted by the State Bar Council.
Yes, yes. Now I recollect.
Yes, Lord.
जी, ठीक है।
So I escaped this, Lord.
Yes.
I'll not read it.
जी,
Then the other judgment is also of the same. The here, Lord, what had happened, the recognition was granted by the Bar Council, State Bar Council, to another bar association. And the same was a subject matter of challenge at the instance of the parent bar association to the High Court. The High Court said, my Lord, the division bench of the High Court said, they have no locus to challenge the same.
जी,
Specifically, my Lord, it was so held. If your Lordship will not want, I would refer to the paragraphs also, my Lord.
yes, yes. बताओ।
It starts from paragraph 29, my Lord,
Yes.
to paragraph 39, 29 to 39, regarding the locus. But it says, Lord, the other association has no right to object for grant of recognition to the state bar by the State Bar Council. So paragraph 29 to 39 are on the locus, Lord, and the other relevant paragraph 73 to 75, even 78 to 84, Lord, on the merits, Lord, that was rightly granted to us. There was no prohibition
जी,
in the rules.
जी,
So, Lord, without reading the entire judgment, Lord, your Lordship would be able to recapitulate from the fact. And if your Lordship permits, I may read it also.
whatever is convenient to you.
Lord, only for not just for ready reference, Lord, I may read it, Lord,
Okay.
because extensively I have argued on the judgment, Lord.
जी, जी,
So, Lord, I have given the relevant paragraphs of the judgment, Lord, in my
Yes.
list also.
सर मेरा निवेदन, इन्होंने 3-4 नई बातें बोली और एक जजमेंट से।
चाहिए वर्मा जी, आप बैठ जाइए, अभी जब आपको बुलाएंगे तब
जी
बताइए,
सर,
प्लीज बैठ जाइए।
जी
और इस तरीके से अनंत बहस नहीं होती है। बैठे रहिए, आप वहीं बैठे रहिए, वहीं बैठे रहिए।
10
नहीं नहीं,
घंटे से बहस कर रहा है मेरे।
ठीक है, आधा घंटा भी नहीं हुआ वो, एंड दैट इज आवर डिस्क्रिशन। यू आर नोबडी टू इंस्ट्रक्ट अस कि हमें कितनी देर सुनना है। प्लीज बैठ जाइए, कुछ नहीं है।
Yes, Lord.
जी,
Therefore, my submission is not, since I just sum up submission as far as the PI petition is concerned, Lord, that we are the Court Elect Bar Association. It was the space was rightly allotted
you have
to us,
spent a
Lord.
lot of amount, now
Yes.
you cannot be approved.
Yes, approved it. Now, Lord, we from the official website of the High Court, my Lord, we have been able to obtain information about the credentials of the petitioner.
जी,
Lord, this is from the official website.
नहीं नहीं, Have you made it part of your return or
रिटर्न में ये कहा कि ही इज नॉट अ पीआईएल पिटिशनर, ये ऑफिशियल वेबसाइट से निकाला गया इंफॉर्मेशन. इन्होंने भी सर सब डॉक्यूमेंट्स फाइल किए एंड दे हैव बीन टेकन, मतलब ऑफिशियल वेबसाइट से, मतलब इट्स इन पब्लिक डोमेन.
they may be in public?
Not kindly similar, I'll just demonstrate it. It's in public domain, my lord. Not, he has also filed certain documents across the board which have been taken on record, my lord.
ठीक है.
So, my lord, this should also be taken on record, which is a part of the public.
You have exhaustively argued on locus and the maintainability
Lord,
of PIS.
I'll demonstrate not from the documents which we have downloaded today from the official website.
You should have filed them.
हम फाइल कर देंगे सर, इस पे एप्लीकेशन फाइल भी कर देंगे सर इसको.
ऐसा नहीं
सर इस पे सर yesterday they had argued they have been permitted to file a document today and that has been taken on record and that was a private document. No, these documents
It's
not
not a
form part
private
of the
document.
public record of the High Court.
It's a picture of a public premises and it's not a private document.
So it was a private, so they obtained a photograph and what the documents which we are trying to file not have been obtained from the official website of the High Court. Not in last 8 years, एक मनोहर ममतानी साहब को लेटर दिया, वो तो प्राइवेट वो भी उन्होंने अक्रॉस द बोर्ड दिया.
वो तो हाई कोर्ट का कम्युनिकेशन है.
हाँ, हाई कोर्ट का कम्युनिकेशन है, ये भी हाई कोर्ट की वेबसाइट से तो हमने निकाला है. It's not a private document, Lord. So, Lord, we have been able to, Lord, in the last 88 years, from 2016 to 2014, hardly 13 or 14 matters have been filed and hardly 11 appearances in the High Court. This are the credentials of the PIL petitioner. Can he be said to be a public spirited individual, my lord?
Without document, we will know.
Lord, these documents have to be taken on record. Lord, that is my submission. The documents which he has supplied have been taken on record, Lord. So, therefore, my humble submission, these documents which are in public domain should be taken on record. These are not the private documents, Lord. We are obtained from the official website of the High Court, Lord. These are the credentials of the petitioner, my lord. Hardly any appearance in the High Court. For few years, nil appearances. Can he be said to be a PIL petitioner at all? Can he be said to be a public spirited individual? Can he espouse the cause of public at large?
I have noted your contention.
Yes, my lord. So, my lord, my submission is, my lord, the documents can be taken on record, my lord.
आप स्टैटिस्टिक्स बता दीजिए. 8 केस में अपीयर हुए ना पिछले.
ये हमने 8 साल में कुल 11 अपीयरेंसेस हैं इनकी. 8 साल में.
ठीक है. कब से कब तक?
16 से 24 तक अभी तक.
ठीक है.
और कोई साल में तो एक भी फाइलिंग नहीं है.
ठीक है.
एक फाइलिंग, 2 फाइलिंग, ये तो पोजीशन है इनकी.
ठीक है.
कैन ही बी सेड टू बी अ लॉयर एट ऑल?
जी ठीक है. बार काउंसिल से जाके पूछिए.
बट वी कैन डेमोन्स्ट्रेट बाय बार काउंसिल तो सबको वो रजिस्टर एनरोलमेंट हो गया. बट नॉट कैन ही बी सेड टू बी एक्टिव प्रैक्टिसिंग लॉयर? Can he file a PIA? Can he file a writ petition by way of public interest litigation? Can be permitted to espouse the cause of the public at large? और इसमें public at large का क्या सवाल? If the space plot,
public at large का तो आप जवाब already बहस कर चुके हैं उनके लोगों के बारे में.
Submission is not whether the space is given to us or not given to us. Not how does it serve the cause of the public at large? This cannot be a subject matter of public interest litigation at all.
So this is the locus of Mr. Amit Patel.
Yes, Lord.
8 साल में 11 अपीयरेंस.
8 साल में 11 अपीयरेंस हमने निकाला है वेबसाइट से.
जी जी. ठीक.
Therefore, Lord, it was rightly argued, my lord, by my learned predecessors, my lord, that he is a sponsored person, Lord.
ठीक.
He has been planted.
Okay.
By the persons having vested interest in the matter, my lord.
Okay. Anything else?
Yes, bro. Then, my lord, the counsel for the, my lord, in respect of that recognition matter, my lord.
Yes.
My learned friend, my lord, for the State Bar Council had submitted that there is no resolution of a bar council, my lord. Resolution of the Bar Association, my lord.
Just a minute.
And they have cited one judgment also.
ठीक है. जी
Yes. I'll read plot section 22 plot of the Society Registration Adhiniyam 1973 plot.
जी
Because we are registered under this act, 73 act.
जी
Yes, plot.
जी
Sued by and against societies. Every society may sue or be sued in the name of the president or chairman or principal secretary or the trustees, as shall be determined by the regulations of the society, and in default of such determination, in the name of such person, as shall be appointed by the governing body for the occasion. So, my lord, the petition has been filed through the secretary. All the pleadings have been signed and verified by the secretary, my lord. The only requirement, my lord, is that every society may sue or be sued in the name of the president of society or principal secretary of the trustees, as shall be determined by the regulation of the society, and in default of such determination, in the name of such person, as shall be appointed by the governing body for the occasion. Now, my lord, we have passed a resolution also, my lord,
अच्छा
authorizing the secretary and other office bearers to file a petition. Lord, those resolutions we have brought on record by way of our rejoinder, my lord. My lord, the objection was taken, my lord, by the High Court Bar Association, my lord, in the return. But it was argued, my lord, by the counsel for the State Bar Council.
जी
Such objection is not in not the we have filed a rejoinder, my lord.
प्लीज कम टू द पेज 11 ऑफ द रिमाइंडर
Yes, my lord. एक पहले जनरल बॉडी का रेजोल्यूशन था, फिर बाद में हमने और रेटिफाई भी किया है।
जी नहीं वो तो ठीक है
जी
पढ़िएगा
जी,
resolution को पढ़िएगा आप
Yes, sir. A special emergent meeting of the members of the association was convened under the chairmanship of Shri Ravi Shakwal Sida Advocate to consider the future course of action in WP number 5193/2006 filed by Shri Amit Patel. The following members so and so, so and so. It was unanimously resolved to constitute a committee headed by Shri Rajan Tiwari Senior Advocate, Shri D.K. Dikshit, Shri Vijay Shukla and Shri Manoj Sharma.
pause there for a minute
Yes, sir.
there is no WP 5193 of 2006
वो सर उस समय दूसरी WP थी, उसमें सर मैं आगे बता रहा हूँ सर,
हाँ हाँ
आगे भी बता रहा हूँ।
बताइएगा थोड़ा सा
यस लॉर्ड।
क्योंकि ये अमित पटेल का 2006 में कौन सी याचिका फाइल हुई ये भी बताना पड़ेगा अब आपको
हाँ एक और फाइल हुई थी सर, वो
हाँ
फाइल
वो बताइएगा कौन सी
जी सर।
क्योंकि प्रेजेंट पिटीशन इज 5193 ऑफ 2016
सर मैं आपको इसी में सर बता, अब मैं आपका आई हैव अंडरस्टूड नॉट योर लॉर्डशिप्स क्वेरीज नॉट आई सेटिस्फाइड,
क्योंकि जितना आप इसको बढ़ाना चाहते हैं हम तो ये सब जा ही नहीं देते सब चीजों में अब आप ले जाना चाहते हैं
सर। उन्होंने सर क्योंकि कहा था इसलिए मैंने बताना पड़ा सर, अदरवाइज नॉट दे हैड माय लर्नेड फ्रेंड हैड रेज्ड एन
आप
ऑब्जेक्शन।
जब ले जाना चाहेंगे तो फिर
नहीं
सवाल
हम नहीं ले जाना चाहते सर,
सवाल को आपको देना
हम
पड़ेगा
उसको
उत्तर देना
रोक
पड़ेगा
देते सर, हम बिल्कुल ले जाना नहीं चाहते।
2006 का कौन सी
हम छोड़ देते सर, हम उसको बिल्कुल नहीं ले जाना चाहते बिकॉज़ माय लर्नेड फ्रेंड हैड ऑब्जेक्टेड नॉट, देयरफॉर आई हैड टू से वी डिड नॉट आर्ग्यू।
जी
Sir, कुल मिला के as far as that petition is concerned, which has been filed by Amit Patel, all those issues are over. Everyone has argued. Now, these are the issues in relation to the recognition matter.
ठीक है ये रेजोल्यूशन दिखा रहे हैं मैं तो उसके लिए बोला मैंने तो कहा
नहीं,
नहीं
हम
कि
छोड़-
मैंने तो कहा नहीं कि आप ऑथराइज नहीं है हमने कभी ये नहीं कहा
नहीं कहा सर आप, वो सर क्या है उन्होंने ऑब्जेक्शन लिया था इसलिए हमको बोलना पड़ा सर।
इशू उठाया तो फिर हमें उस
हमने सर इशू नहीं उठाया सर,
डॉक्यूमेंट देखेंगे
नहीं सर
Document
हमने
आप-
वो इतना मटेरियल भी नहीं
नहीं
है
है,
कि
हमने
आप
सर
देखें और हम उठाएं।
उठाया
हम डॉक्यूमेंट आंख मूंद के नहीं देखेंगे
सर, हमने इशू भी नहीं
तो मुझे
उठाया
मालूम है कि आप आंख मूंद के कुछ भी नहीं देखेंगे।
सर, हमने इशू भी नहीं उठाया, Both,
I think
Lord,
we
it was
need to
raised,
keep that
not
part,
there.
sir. It is
हम
not
छोड़ देते
necessary and
सर
relevant
उसको.
at all.
Lord, it was raised, therefore I had to answer. Otherwise, we would not have said so. And the High Court Bar Association, Lord, had filed a petition before, had filed an application, Lord, before the State Bar Council. There, it was rejected. Therefore, we had to file a petition, Lord. That is all, Lord. Then, my Lord, and the one of the judgment which they had cited, division bench judgment, my Lord, that has no application at all.
जी बताइए.
That is all I'll say, my Lord. If a Lord are not going to into that matter, I'll not touch that issue at all.
नहीं, you please address it.
अब वो चूंकि उन्होंने उठाया था इसलिए हमको
हाँ, बिल्कुल.
नहीं तो हम तो कहते ही नहीं साहब इसको. This was not an issue at all.
जवाब दीजिए, पेज 11 भी पढ़िएगा.
जी पढ़ देते हैं
पढ़िएगा.
जी. और वो क्या है कि वो उस दिन रिकॉर्ड सब जो नोट्स रिकॉर्ड किए सर उसमें भी आया है.
लाइटर साइड, बिगर फीस के वकील कितना लापरवाह हो सकता है, इसका ये उदाहरण है.
नहीं सर लापरवाही नहीं सर. नहीं
ना वकील से फीस जब मिलती है तभी प्रोफेशनल होता है.
नहीं सर ऐसा नहीं है.
चलिए पढ़िए, पेज 11
सर
पढ़िए.
आप देख रहे हैं हम लोग बिना फीस के मुकदमे में कितनी मेहनत कर रहे हैं सर. We have been arguing a lot at the top of our voice for days together, my lord.
पढ़िए, पेज 11 पढ़िएगा.
पेज 11
रिजॉइंडर का.
ये 2016 का है ये.
हाँ ठीक है, पढ़िए ना, पढ़िए तो.
हाँ वो 2006 गलत लगी पिटीशन का नंबर 16 है सर वो.
हाँ.
जी. It was unanimously resolved to constitute a committee headed by Shri Rajendra Senior Advocate so and so, Shri D.K. Dikshit, Shri Vijay Shukla and Shri Manoj Sharma will be associated to prepare draft written of WP number so and so which would be
5196 बटे 16.
हाँ 5196
And 5196 is not a petition.
हाँ not a petition. हम आगे पढ़ देते हैं सर.
जी.
It was further resolved to file a writ petition for forthwith seeking a direction to the State Bar Council to consider the application by association for recognition.
जी.
The committee headed by Shri Tiwari with his associates would make immediate steps to file writ petition by next Monday. So we filed a writ petition, my lord, for this, my lord. This is 7551 of 2016 was filed, my lord.
जी.
Then, Lord, we have passed another resolution, my lord, on 23/1/2024, ratifying with all the acts.
जी.
Ratifying, my lord.
जी.
All the acts.
क्या इम्पैक्ट होता है?
Otherwise, also, my lord, we have ratified, my lord. Then, my lord, the one judgment of the division bench of judgment was cited, my lord. There, my lord, the association had filed a petition on behalf of the members. The cause was of the members. The association filed a petition espousing the cause of the members. My lord, I'll just read the facts of that case. That judgment has no relevance here, my lord, at all.
साइटेशन बताइए पहले.
ये सर अनरिपोर्टेड जजमेंट उन्होंने दिया था सर एक. ये स्वच्छता ग्रही संघ जनपद पंचायत निवास.
अच्छा.
इन्होंने सर एक दिया था.
ओके.
वो आपने रेफर भी किया था नोट्स में सर.
ठीक है, तो वो आएगा, नोट्स में है
सर एक
तो
कॉपी सर हम आपको और करा के दे देंगे.
हाँ प्लीज दे दीजिए.
दे दीजिएगा. तो इसमें क्या था सर, द फैक्ट्स वेयर the brief बहुत ही छोटा जजमेंट है सर ये. The brief facts of the case are that the appellant petition number 1 claims to be a स्वच्छता ग्रही संघ जनपद पंचायत निवास district Mandla, and petition number 2 is the member of the said संघ. Appellant petition number 1 संघ has been registered with an object to serve the interest of its members by maintaining the services as mobilizers working in various gram panchayats within the area of Janpad Panchayat. It is stated that many mobilizers have been appointed and discharging their duties without any complaint. However, in view of certain amendment in the existing instructions, by the order dated so and so, the services of all existing mobilizers have been discontinued. Therefore, the appellant petition number 1 Sangh has prayed that the order dated 8/1/2021, whereby new selection process for appointment on the post of mobilizer of Janpad Panchayat has been commenced, be set aside, with a further prayer to issue directions to the respondents to continue them on the said post plot. So, my lord, the services of the mobilizers were sought to be discontinued, my lord. Their cause was sought to be espoused by the association, my lord. Now, my lord, paragraph 7 of this judgment says, my lord, the division bench of this court in the matter of Prabhat versus Barkatullah University has held that a writ petition for the enforcement of the rights of its members as distinguished from the rights of the association as a body can be filed by the association acting through its office bearers or members, whether the association registered or unregistered, incorporated or not, only when the association can satisfy the court that if an adverse or decision is given in that petition, all the members of that association or body of individuals will be bound by the decision. It has also been held that if the same principle is not followed immediately after adverse decision, any other member of the said association may come before the court in an independent petition saying that he has not been heard and he had not authorized such association of his brother or member to represent him in the litigation. But here is not the question here. The association itself is fighting for its own cause. We filed a petition, my lord. There's no question of not any member coming. No member could have filed a petition for this purpose, not for the purpose of recognition. Only the Bar Association is authorized or competent under the rules, not 2015 rules or 82 Adhiniyam, to make an application for recognition. And we made an application for recognition which was rejected, and therefore the petition was filed by the association, my lord. So, my lord, the judgments, my lord, are altogether different footing. That has no bearing at all here, my lord. No member can come forward and say that the recognition was not, that recognition was incorrectly denied or not, they can file a petition. But it is only the Bar Association who can do it, my lord. So Bar Association is fighting for its own rights. So as distinguished from the rights of the members, my lord. There, my lord, the rights of the members was sought to be espoused. So the situation was altogether, the fact situation altogether different. And the statutory rules provides, my lord, that only the Bar Association can make an application. And if it is rejected, we have to file a petition.
जी.
Then, my lord,
आपके bylaws लगाए हैं आपने?
हाँ, bylaws लगाए सर,
Annexure
लगे, P2 है सर.
P2.
Then, my lord,
अच्छा, देखें P2 में क्या लिखा है. ठीक. जी. जी.
yes. Then, my lord, the application, my lord, for recognition was rejected by the Bar Council for the second time on 5/2/2018.
Yes.
5/2/2000, which is an impugned order 812,
Yes.
C12. This was subject matter of challenge by way of amendment application, my lord.
जी,
And the amendment was allowed
जी,
on 17/3/2023
जी.
or in November 2023, my lord. Sorry. Not thereafter, the Bar Council has not filed any counter affidavit. This is very essential. They have not filed any counter affidavit. We have filed an application for amendment. We have raised grounds also, my lord, of challenge by way of amendment application. The same was not challenged.
जी.
Yes.
Where is Mr. विपिन यादव? जवाब दीजिएगा इस बात का कि आपने क्यों नहीं फाइल किया अमेंडेड पिटीशन का. That means that you concede to what they are saying.
Well, in fact, if Lordship may kindly see the order sheet, in fact, I was not given any opportunity.
आपने मांगी थी, अपॉर्चुनिटी मिलती
सर
है.
उसके बाद सिर्फ सीधे फाइनल हियरिंग पे लग गया. And in fact,
आपने बहस की, आपने कब टाइम मांगा?
नहीं हमने टाइम नहीं मांगा सर. मतलब
फिर
what my respectful submission, if Lordship may kindly see the amendment application.
we are not concerned with it. We are not going to
Yes.
the marriage. If there is some substantial amendment and if you are not giving reply, then the law of pleading says that by virtue of non-denial, they are admitted.
Well,
Non-drivers.
they have only added in the paragraph and the relief clause. I'll answer, my lord. Let him answer.
हाँ, ठीक है.
Lord, the first letter of the High Court for the State Bar Council was filed on 20/2/2017.
जी.
Not prior to that, Lord, one date is very important, Lord. The BD Kaushik judgment had come on 26/9/2011. 26/9/2011 को BD कौशिक का जजमेंट आ गया था.
जी.
20/2/2017 को स्टेट बार काउंसिल का रिप्लाई है. हाई कोर्ट का जो ऑर्डर है, जो डिवीजन बेंच का ऑर्डर था सर 22/2/2017 का, in which the direction was given to the state bar council to consider our application, my lord. उसके बाद का है 22/2/2017 का है. The dates are relevant, my lord. And when the order was given, my lord, they decided our application by an impugned order dated 5/2/2018, my lord.
There is P12.
P12, my lord. We brought it by way of an amendment, my lord. I just referred to the amendment application also.
जी.
And we have raised grounds also, my lord. If your lordship would see this amendment application,
जी.
we have added 3 grounds, 6.8, 6.9, 6.10. We have added the grounds also. That by the impugned order dated 5/2/2018 P12 passed by the respondent number 2 is contrary to law and has dehoused the Advocates Act 1961 and the rules for recognition of bar association by the State Bar Council of MP 1975 and is therefore liable to be set aside. That the State Bar Council was directed to consider the application in accordance with the judgment and statutory provisions applicable in the matter of recognition of bar associations. However, while passing the impugned order dated 5/2/2018 P12, it is crystal clear that the same have not been considered by the State Bar Council. The impugned order reflects complete non-application of mine by the State Bar Council and is also violative of order dated 22/2017 passed by this Honorable Court and therefore deserves to be set aside. That the approach of the respondent number 2 in rejecting the application of the petition is paradoxical as the respondent number 2 itself admits in the impugned order dated 5/2/2018 that there is no bar in granting recognition to more than one association at a single place. Lord, I had already referred to the order, Lord, on the last date of hearing. I'll just refer it, Lord, for the purpose of, Lord, to recapitulate the things, Lord, if your Lordship permits.
Please.
Yes, P12, Lord.
P12. Filed along with the amendment application.
Yes. On due consideration of the submissions made as above, we find that all the 330 advocates on roll of membership of the applicant association are members of the object association with their participation in the election and other schemes carried out by it, and taking note of the fact, we find the senior advocate and the president of the object association to be proper person to be heard in the matter. Section 6(1) DD of the Advocates Act 1961 requires
किस पैराग्राफ पे पढ़ रहे हैं?
सर ये पैराग्राफ सर हम पेज 10 से पढ़ रहे थे, इंटरनल अमेंडमेंट एप्लीकेशन का पेज 10 है सर, रनिंग पेज 10 है सर, बॉटम ऑफ द पेज।
जी, तो उस दिन बता दिया था आपने।
हाँ बताया था सर, बताया एक्सटेंसिवली पढ़ भी दिया था।
हाँ
Just for ready reference, if a lordship permits, but I'll read it. Otherwise, not I'll escape it.
जी
But if a lordship come down to the middle of the page, Lord, only one paragraph. As submitted on behalf of the applicant association, lordship got it.
पेज 11 में।
Yes, page 11, the middle of the page.
यस
As submitted on behalf of the applicant association, undoubtedly there is no bar in giving recognition to an association of advocates where a similar recognized association is in existence. But at the same time, we find nothing in any act or rules made thereunder to give recognition to every association who makes application for the purpose and is technically eligible for the same. Not the High Court, not in its order dated 22/2017 has said that there is no bar to give recognition to a second bar association. Yet, my lord, they have said we will not give recognition to you. So, my lord, this order, my lord, is a derogation to the order of the High Court, my lord, dated 22/2017.
जी
But they themselves have come to a conclusion there is no bar. There is no technical bar.
जी
Either in the 1982 Athenium, my lord, or 2015, there is certificate of place and practice verification rules, my lord. There is no bar. And we fall within the definition of the bar association defined in both the, my lord, the statutory, the Act, my lord, 82 Act and the rules 2015, my lord.
तो हाई कोर्ट ने क्यों नहीं रिकॉग्निशन दे दिया?
जिससे
स्टैट्यूटरी बॉडी की कोई रिक्वायरमेंट ही नहीं है।
नहीं है, कोई जरूरत ही नहीं।
कोई जरूरत ही नहीं, तो हाई कोर्ट could itself could have said that we have allotted space
We have
and we grant recognition to the High Court Advocates Bar Association.
well, we have been granted recognition to existence of our association. But this was only for a limited purpose. Not if I had referred to the provision of the Act for a limited purpose, that so that our members can avail benefits of the welfare schemes of the Bar Council. Not I'll again refer to the provisions of the Advocates Act that the Adhivakta Kalyan Nidhi Adhiniyam, my lord. If a lordship would say Adhivakta Kalyan Nidhi Adhiniyam, my lord, I'll refer. Again, it was only for a very limited purpose. Otherwise, not.
इसको मिस्टर अग्रवाल पहले इसको पढ़ने के पहले आपके एसोसिएशन के एम्स एंड ऑब्जेक्ट्स तो देख लीजिए, उसमें क्या है कि आप अधिवक्ता कल्याण निधि का और इसका फायदा देना चाहते हैं।
नहीं, इसमें सब ये है।
नहीं, एक सेकंड
जी सर।
You can not travel beyond the aims and objects of formation of your association. Does your aim and object provide that you will be a body providing benefit of Adhivakta Kalyan Nidhi or the beneficial acts to the members who are going to be associated with you?
ये सर रिकॉग्निशन तो हमको तब आएगा।
This can be deciphered only from your aims and objects.
ये हमको तो पावर तब आएगा जब हमको वहां से रिकॉग्निशन मिलेगा।
नहीं,
मतलब आप यहाँ पे अगर देखें
पहले एम्स एंड
क्लॉज
ऑब्जेक्ट नहीं ऐसा नहीं होता। पहले हम अपने एक सोसाइटी बनाएंगे, सोसाइटी में एम एंड ऑब्जेक्ट में डाल देंगे कि हमें मेडिकल कॉलेज खोलना है। उसके बाद जब हमको एमसीआई या और अन्य बॉडीज जो है और यूनिवर्सिटी जो है रिकॉग्निशन देगी, तब हम मेडिकल कॉलेज चालू कर पाएंगे। इसका ये मतलब थोड़ा ना कि जब हमें जो है एमसीआई रिकॉग्निशन दे देगा
क्लॉज 3 से सब कवर हो जाएगा सर।
पढ़िए
Clause 3.
पढ़िए क्लॉज 3
To
पढ़िए।
promote and protect the interests of the legal fraternity generally and the particularly advocates practicing in the High Court of Judicature at Jabalpur, inclusive providing facilities for study, library, a place for work, rest, etc. to its members, and generally to concern itself with all aspects of legal education and any other matter or thing affecting in any way or relating to the legal profession in India or abroad, to promote and maintain a high standard of professional ethics, to determine so and so. So, इसमें उससे to do all such things as are incidental, ancillary or conducive to the attainment of the above objects. अगर हम वहां से रिकॉग्निशन के लिए अप्लाई करेंगे, 2 सर्टिफिकेट ऑफ प्रैक्टिस 2015 में आए, वहां हमने अप्लाई किया, या हमारे एसोसिएशन के रूल्स बायलॉज तो 2006 के हैं।
ठीक,
तो उसमें जब ये आ गए तो हम अगर आप बार एसोसिएशन की डेफिनेशन देखेंगे सर, उसमें जो है दिया है सर्टिफिकेट ऑफ प्लेस एंड प्रैक्टिस वेरिफिकेशन रूल्स में बार एसोसिएशन की जो डेफिनेशन है 4G
2015 के नियम में
4G
पढ़िए 4G पढ़िए।
Bar Association of a given area, town, city means an area, territory and court work based association of advocates whether registered under the Society Registration Act or not, having its area territory defined in terms of the whole or part of the territorial jurisdiction of courts, tribunals, persons or any other authorities legally competent to take evidence before which its members ordinarily practice law, and it includes bar association exclusively dealing in specific fields of law, namely income tax, corporate law, central, state, excise law, etc., in relation to the authorities, tribunal, so and so. So, the Bar Council did not say that we are not a bar association. We do not fall under clause G. Or, my lord, as the Bar Association defined, my lord, in they did not say that. This is not the case of the Bar Council, that we do not fall in within the definition of 4G. They say, we will not give it to you. We don't want to give it to you. इसी तरह से सर जो है अधिवक्ता कल्याण निधि अधिनियम जो है वो जो एडवोकेट की डेफिनेशन मैंने 2A रेफर भी किया था, ये एमपी लॉस मैनुअल पे है सॉरी। ये वॉल्यूम 2 है सर, पेज 37। If your lordship would see the preamble of the act. An act to provide for the constitution of a welfare fund for running various schemes for the social security and welfare of advocates in the state of Madhya Pradesh and for matters connected therewith or incidental thereto. Then, my lord, the definition of an advocate, A, clause A. Advocate means a person whose name has been entered in the state roll of advocates prepared and maintained by the Bar Council of Madhya Pradesh under section 17 of the Advocates Act, and who is a member of a bar association. That bar association is defined in clause B. Bar association means an association of advocates recognized by the Bar Council under section 16. Now, if your lordship would see section 16. So, not only that advocate who is a member of the bar association would be entitled to get the benefits of the welfare scheme.
16 क्या कहता है?
Recognition and restriction and registration of bar association. So, made an application under section 16.
हाँ बताइएगा ना.
An association of advocates known by any name, functioning in any part of the state, may, before a date to be notified by the Bar Council in this behalf, apply for recognition and registration to the Bar Council in such form and on payment of such annual subscription or other fees as the Bar Council may from time to time determine. So, this application to dismiss only on the policy decision that there cannot be a two recognized bar at the same place.
Right.
That was on the basis of policy decision that application was rejected. So they did not say, not the State Bar Council did not say that we are not the bar association as defined and either under the 82 Adhiniyam or the 2015 rules. Earlier application was rejected on account of policy decision. The subsequent application has been dismissed not for no reason or rhyme, in spite of a clear-cut direction of the High Court. And they say, my lord, the finding has been arrived at the Bar Council that there is no technical prohibition for grant of recognition to a second bar association at the same place. Yet we will not grant. Yes. Then, my lord, I'll just sum up, my lord. They have also taken shelter of the 1975 rules, my lord. 75 रूल्स जो है इन्होंने अपने रिटर्न के साथ स्टेट बार काउंसिल ने लगाया सर, उसे पूरे रूल्स को कोट किया हुआ है, उसमें कोई प्रोहिबिशन नहीं जी। अब ये कोई स्टैट्यूटरी उसमें भी फ्रेम नहीं किया कोई पावर में, लेकिन इन्होंने एक रूल्स बनाया, उसमें कोई प्रोहिबिशन भी नहीं है. It only says whereas the State Bar Council of Madhya Pradesh is promoting various schemes under Section 6 of the Advocates Act 1961, and whereas these schemes are to be implemented through the bar associations, it has become necessary to frame rules for the recognition of bar association so that they may be recognized by Bar Council for such a scheme. A bar association, then recognized bar association, my lord, means a bar association recognized by the Bar Council of Madhya Pradesh under these rules, my lord. These rules have not been framed in exercise of any statutory power, but these rules are there, my lord. And they don't run counter, my lord, to 2015 rules. The 2015 rules, my lord, I have already referred to 4G
Yes.
and Rule 6, my lord.
Yes.
6.3.
Yes.
6.1 is also important, not, and 6.3.
पंद्रह के रूल्स निकाल के दीजिए पिटीशन में.
ये सर एडवोकेट्स एक्ट की बुक में भी है पीछे सर,
एडवोकेट है.
उसमें ब्यूरो बुक में पीछे है सर. ये दिस इज एट पेज पीछे दिए हुए पेज 75.
Special provisions relating to bar council and advocates in the नहीं
ये पेज 75 है सर.
आपके पास
हाँ हमारी जो बुक है उसमें
लीजिएगा. बात का कोई
रूल्स हमने सर लगाए. P8 है सर वैसे.
P8 है तो देखिए.
P8 है सर.
P8.
पेज 51 ऑफ द पिटीशन.
जी जी जी. हाँ लगाए हैं आपने ये.
Yes sir. P8.
जी
Sir, 4G, my lord, I have already referred, my lord.
जी.
Then 6.1. At page 55. Sir.
Yes.
An advocate, after having obtained a certificate of enrollment under Section 22 of the Advocates Act, is required to get himself registered as a member of the Bar Association where he ordinarily practices law or intends to practice law. And if any advocate does not intend to be a member of any bar association duly recognized by concerned State Bar Council, then he shall be required to intimate the same to the State Bar Council, and he shall have to explain as to how shall he be getting the benefits of any welfare scheme floated by the State Bar Council or the local bar association. The decision of the State Bar Council shall be final in this regard. Then 6.3. Bar associations to apply to the respective bar council within whose jurisdiction they are located for being recognized under these rules. Recognition shall be accorded to such a bar association only which falls within the definition of bar association as defined in these rules. So, Lord, we are the bar association defined under these rules. This is not in dispute. So, Lord, if we are an association defined under these rules, we ought to have been granted recognition. And this is what the division bench of the High Court had also directed on 22/2017.
जी.
It was argued that specific grounds have not been challenged, have not been taken. What I have referred to the specific grounds which we have taken not in the amendment application. बता दिया सर बस, क्योंकि इनका कहा था ऐसा, वो आपने नोट किया था जो इनके थे, उसका हम आंसर दे रहे हैं सर. So my submission is blocked.
That you should be given recognition by the bar council.
Yes.
And the PIL should be dismissed.
Yes.
And electricity bill should be waived off.
Yes.
But as far as the amendment is concerned, my lord, what my respectful submission is, my lord, that during the pendency of the case, when the case was being finally heard, on 1/11/2023, that application was allowed. And on 2/11/2023, at the time of hearing, sir, it was allowed. In fact, I filed my वकालतनामा on 30/11/2023. But as far as
depend करता है कि आपको कब वकालतनामा
no, but as far as the merit of the concern, my lord, if lordship may kindly see, as far as the facts,
को जवाब देना है.
नहीं मुझे जवाब नहीं देना सर. I'll satisfy your lordship on these facts and grounds concerned, my lord. As far as the facts are concerned, lordship, they moved an application for amendment, as far as the facts are concerned, they have added 5.33, sir, in the facts clause, sir, wherein they have only annexed the order annexure P12. Although they have added 3 grounds in ground clause also, but the reason, they have not discussed the reason on which the impugned order has been passed. What my respectfully submission is, my lord, that in their amendment application, they have not challenged the finding given by the Bar Council. They have challenged the order on different grounds. I read that findings also, my lord. So what my respect, the first is because it is a settled law, my lordship, that the order, whichever order is the impugned order which is under challenge, the validity of that order should be checked on the basis of the reasoning given in that order. That reasoning they have not discussed and not argued. In fact, at all, they are silent about it. Your lordship may kindly come to the impugned order at page 9, sir. Because the Bar Council has given the specific reasoning. Whatever they have argued, that was not the reasoning. Specific reasoning has been given, and that has not been challenged, and that has not been discussed in their grounds. Now, reasoning I would like, because it is an enabling provision, my lord, to grant the recognition or not to grant. It's not a mandate. How they have dealt with, if lordship may kindly say page 9, last paragraph, so I'll read it. It has further been contended that in the record of MP State Bar Council, all the 330 advocates are recorded as the member of the Objector Association. It has been emphasized that Sri Anil Khare, Senior Advocate, and Sri Pranay Verma, Advocate, are placed as CL number 49 and 108, respectively, and Sri Ajay Kumar Jain, Advocate, placed as CL number 330 in the role of membership of Objector Association. Contested election for the office of President of the Objector Association held in October 2016. The names of present Secretary Sri Shashank Shekhar, Advocate, and Sri Manish Tiwari, former Secretary of the Objector Association, also appears at serial number 233 and 105 respectively of the list of 330 advocates. Similarly, Sri Wajid Haida, Udyan Tiwari, Sri Sanjay Verma, Sri Anup Nayak, Srimati Nirmala Nayak, Sri Hitesh Nagdev are convened the member of the different subcommittee of the Objector Association. It is submitted that all of the 33 advocates said to be on roll of membership of application associations are availed benefit of all the welfare scheme of the State Bar Council and the Bar Council of India. And there has never been any complaint that they have been deprived of any benefits. Out of the 330 advocates, most of them are having their seats in the Vidhi Bhavan and Shan Jayanti Bhavan of the Objector Association, and most of the members of Vidhi Bhavan are in possession of the advocate so enlisted by the applicant association and are availing the facility of library, e-library, and all other facilities in the Silver Jubilee Hall of the Objector Association, and have never been deprived of any benefit of facility on the ground inter alia that their name appears in the list of membership of applicant association. The Objector Association is providing a scheme known as Adhivakta Parivar Kalyan Yojana 2014, equally applicable to the 330 advocates enlisted in the list of applicant association. The interest of the Objector Association is the interest of about 1,600 advocates, including the 330 advocates who are on the roll of membership of the applicant association, who are also member of the Objector Association. Then I am skipping this para, next para. On due consideration of the submission made as above, we find that all the 330 advocates on roll of membership of applicant association are members of the Objector Association with their participation in the election and other schemes carried out by it. And taking note of the fact, we find Sri Adarsh Muni Trivedi, the senior advocate and the president of the Objector Association, to be a proper person to be heard in the matter. Section 6(1)(dd) of the Advocates Act 1961 requires the State Bar Council to promote the growth of bar associations for purpose of effective implementation of different welfare schemes provided to the advocates, but the applicant association has never stated that they are being deprived of any of the benefits of any welfare scheme which they ought to have availed, or in case their association is recognized, how it shall be to the betterment of the advocates on their role of membership. Thus, we don't find that giving recognition to the applicant association shall in any way be to their betterment or they will achieve something more except to dissociate from the existing recognized bar forming a small group of advocates, disintegrating the advocates' practice in the High Court at Jabalpur in two parts, having their different voices on different issue of the advocates. As submitted on behalf of the applicant association, undoubtedly there is no bar in giving recognition to an association of advocates where a similar recognized recognition is in existence. But at the same time, we find nothing in any act or rules made thereunder to give recognition to every association who makes application for the purpose and is technically eligible for the same. Section 16 of the Advocate Act and the rules for the recognition of bar association by the State Bar Council of Madhya Pradesh 1975 are only enabling in nature and does not provide mandate for the purpose. Sub-Rule A of Rule 4 provide for withdrawal of recognition of the bar association in case of its membership falling below 50% of the advocates practicing at such place, as is evident from the list of membership of the objector association, the existing recognized bar, and the applicant association that 1600 advocates practicing in High Court of Madhya Pradesh at Jabalpur are on roll of membership of the objector association, whereas...
Sir, you already made a point that...
So what my respectfully submission is about, none of the 300 members have resigned. In the Madras case, the person who have formed the separate association, they have been expelled. So that case is different.
Yes.
Here in this case, the members are common.
Okay.
So it cannot be said that the Bar Council has not applied their mind and they have violated the principle of, and they have only applied the matter of one bar, one vote. It's not the case. Because there are certain circumstances. There are already one bar is existing. There is no occasion to grant bar within bar. There is no such provision is prescribed. And that's why there is a due application of mind. And the order has been passed. It is not the case that the 300 members have resigned from that and they are forming a separate bar association. Then the matter would have been different. They can get the recognition. But when there is already one bar is existing and recognition has been granted and the members are getting the benefit, because recognition is only for the benefits. So that purpose is already being achieved. So there cannot be any amendments for the forming of grant of recognition. This is only my respectful submission. And these findings, they have, what my respectful submission is, because these findings they have not challenged. Right. They have not said anything in the amendment application in respect to these findings. When these findings are not challenged, all the order is based upon these findings. So only the reasons given in the order that should be seen. Right. That's all.
किस केस में आ रहे हैं आप?
7551.
7551. हाँ, बताइए.
अभी सर इन्होंने जैसा कहा कि अधिवक्ता कल्याण निधि अधिनियम के अंतर्गत जो इनके मेंबर हैं उनको बेनिफिट मिलना चाहिए, इसलिए ये रिकॉग्निशन के लिए अप्लाई किया, अदरवाइज इनको जरूरत नहीं है रिकॉग्निशन की.
जी
सर, एक इनकी पिटीशन में सर प्रेयर और ऑब्जेक्ट दिखेगा आपको सर.
इंटरिम रिलीफ का क्लॉज देखेंगे सर.
एक सेकंड.
सर इनके रिज्वाइंडर के रिप्लाई के लिए बोल रहा हूं मैं क्योंकि मेरा पूरा जवाब फाइल किया हुआ है सर.
किसमें?
इस केस में कंप्लीट जवाब है मेरा.
डॉक्यूमेंट नंबर?
जी सर, डॉक्यूमेंट्स नंबर
आपके जवाब का कुछ आईए नंबर होगा ना?
एक सेकंड सर. आईए नंबर 277 सर.
277 2024.
24.
जी बताइए.
इसमें सर प्रेयर क्लॉज देखेंगे आप. इंटरिम रिलीफ
पिटीशन में मिलेगी इंटरिम रिलीफ.
हाँ, इंटरिम रिलीफ 26 पेज वही मैं. In view of the facts and circumstances of the case, considering the facts that the process of verification rule under 2015 has commenced, the respondent number 2 be directed to grant the provisional recognition to the Bar Association during the pendency of petition. the object behind to file the petition. अब इन्होंने रिकॉग्निशन कैसे ली, कहां से ली, ट्रेस ऑफ प्रैक्टिस कहां की डिक्लेयर की, किस बार एसोसिएशन को अडॉप्ट किया, ये 300 मेंबर के बारे में जैसे अभी विपिन यादव जी ने बताया, बार काउंसिल के वकील साहब, उन्होंने ये कहा कि ये मैक्सिमम लोग हमारे यहाँ मेंबर हैं और कुछ लोग डिस्ट्रिक्ट कोर्ट में मेंबर हैं। अब सर जो सर्टिफिकेट एंड प्लेस ऑफ प्रैक्टिस वेरिफिकेशन रूल 2015 है, उसका सेक्शन रूल 6 क्लॉज 1 मैं पढ़ता हूं सर। एन एडवोकेट आफ्टर हैविंग ऑब्टेन अ सर्टिफिकेट ऑफ एनरोलमेंट अंडर सेक्शन 22 ऑफ द एडवोकेट एक्ट 61 is required to get himself be registered a member of the bar association where he ordinarily practice law or intends to practice law. If any advocate does not intended to be a member of bar association duly recognized by concerned state bar council, then he shall require to intimate the same to the state bar council, and he shall have explained how shall be getting the benefit of the welfare scheme floated by the state bar council or a local bar association. The decision of the state bar council shall be final in this regard. सर ये कह रहे हैं 2007 से हमारा बार एसोसिएशन वर्क कर रहा है। ये इन्होंने डिस्क्लोज क्यों नहीं किया कि बार एसोसिएशन में कि हम कैसे बेनिफिट दे ले रहे हैं या ले रहे हैं। एवरी मेंबर ऑफ दैट बार एसोसिएशन इज द मेंबर ऑफ द रिकॉग्नाइज्ड बार एसोसिएशन। दे हैव नॉट रिजाइन फ्रॉम द एनी बार एसोसिएशन।
तो कल बता दिया, इन्होंने बता दिया,
ये बताया सर। तो इसके ऑब्जेक्ट से इनको रिकॉग्निशन की जरूरत नहीं है। दिस पिटीशन बिकम रेंडर्ड इनफेक्चुअस फॉर द पर्पस ऑफ रिकॉग्निशन because they are getting the benefit from the other bar associations.
जी जी जी।
और वो प्रैक्टिसिंग के लिए सर उनके सारे लोगों ने डिक्लेयर किया है सर, हाई कोर्ट बार एसोसिएशन या डिस्ट्रिक्ट बार एसोसिएशन द प्लेस ऑफ प्रैक्टिस। अदरवाइज दे कैन नॉट बी अ डिक्लेयर एज ए प्रैक्टिसिंग एडवोकेट।
जी।
No member has said that they are not the member of the any recognized bar association. अब सर जो सेक्शन 22 सोसाइटी रजिस्ट्रेशन एक्ट के अंतर्गत मेरी आपत्ति थी उसमें कि वेयर इज द रेजोल्यूशन इफ देयर इज अ रूल डज नॉट प्रोवाइड टू फाइल अ सूट, either the president or a secretary, there has to be a specific rule regarding that for filing the petition.
Yes.
If there is a no rule, then there is a resolution for a specific purpose.
जी।
That they have annexed it, whether that is the resolution for the specific purpose or not.
जी।
इसमें सर एक ऑर्डर शीट मैंने फाइल की हुई है।
एक मिनट, सेक्शन 22 फिर से पढ़ते हैं।
जी सर।
सोसाइटी रजिस्ट्रेशन एक्ट का सेक्शन 22 फिर से पढ़ते हैं।
मिल गई
आपके पास।
सर may I read that sir?
22।
Yes.
Yes, just a minute।
Sued by
Yes।
every society may sue or be sued in the name of the president or the chairman or the principal secretary or a trustees, as shall be determined by the regulation of the society. In default of such determination, in the name of such person shall be appointed by governing body of the.
जी।
There has to be specific. This person has been authorized to file a petition. That resolution is not there.
जी।
And the rule does not provide the secretary or president or a general secretary or a trustee or a treasurer.
जी जी और बताइए।
जी सर, इसमें सर प्रेयर सर देखेंगे इनकी। First prayer is a clause 7.1, the dated 25/11/2005.
जी
The resolution is under challenge. The petition is filed on 2016. And my lord, the clause for explaining the delay is not adequate and my lord, the proper. See the clause 4, my lord, the Bar Council of India framed the certificate and place of practice verification rule 2015, which came into effect on the publication of the same in the Gazette of India, Part 3, Section 4, dated 13/1/2015. It was therefore, on coming in force 2015, rule that the petitioner association applied for its recognition under Rule 6.3. The object to challenging it for the declaration of place of practice and obtaining the certificate in 2015. So everybody has obtained the certificate from the Bar Council and they declare the place of practice where they are practicing it.
आपने बताया अभी।
हाँ सर, ये तो 2005 का 16 में इसमें एक्सप्लेनेशन नहीं होता, ऑब्जेक्ट पर ये दे रहे थे कि हमको सर्टिफिकेट प्लेस ऑफ प्रैक्टिस चाहिए। अब उसके बाद सर इसकी दूसरी प्रेयर भी 2007 की है, तीसरी 2018 की चैलेंज करते हैं सर 24 पे 23 पे 1/11/2023 का अमेंडमेंट है, कोई एक्सप्लेनेशन नहीं है डिले का। दिस पिटीशन इज hit by the delay and laches, it has to be dismissed on the ground of that.
और कुछ?
एक सेकंड। अब सर
आपको आपके सेक्रेटरी सामने ब्रीफ नहीं किया क्या?
सर किया है प्रॉपरली,
किया है तो बताइए। चलिए
सर, बार एसोसिएशन वर्क कर रहा है। रेस्पोंडेंट नंबर 3 इज द ड्यूली रिकॉग्नाइज्ड बार एसोसिएशन एंड my lord, till today, as per my knowledge, the more than 3,000 advocates are practicing advocate and they have obtained the recognition from the bar certificate from the Bar Council of State. And my lord, for a moment, if this particular petitioner get the recognition, meaning thereby everybody is having the right to get the recognition from.
तो उसने आपने बता दिया था
वो इसलिए
वो वर्मा जी ने भी बहस कर दी कि ओबीसी वेलफेयर एसोसिएशन की भी पिटीशन पेंडिंग।
कल सभी आएंगे सर, सब मांगने लगेंगे और एक क्योस डेवलप हो जाएगा। R3 इज बिल्कुल वही ऑब्जेक्शन फाइल किया हुआ है दी देन प्रेसिडेंट मिस्टर आदर्श मुनि त्रिवेदी। उनका ऑब्जेक्ट ही 28/2/2017 का जो इनका जो रिकॉग्निशन की एप्लीकेशन थी उसको ऑब्जेक्ट किया, दैट इज R33 पेज 21 से शुरू होता है सर।
प्लीज एक मिनट देखते हैं। जी
और सर बार बार ये कह रहे हैं सर कोर्ट एनेक्स्ड बार एसोसिएशन। कोर्ट एनेक्स्ड बार एसोसिएशन मींस मध्य प्रदेश हाई कोर्ट बार एसोसिएशन विच इज ड्यूली रिकॉग्नाइज्ड। If the person is practicing in Central Administrative Tribunal, if the Bar Association is working in the Central Administrative Tribunal, that means that Bar Association is the court-attached Bar Association. The more than one bar cannot be attached. If kindly see the definition which is given under the practicing place of practice rule verification 2015, my lord, that word used, my lord, if my lord,
देख लिया वो बहस हो गई है.
that is crystal clear. That does not mean they are taking the advantage of that they are working in the court attached bar association. That does not mean that they are recognized bar association. And my lord, the person who is conducting the lecture series and calling the dignitaries, that is not the reason, that is not a ground for the recognition. And my lord, in nutshell, the one bar association is duly recognized. And the maximum persons are the member of that bar association. Therefore, the second bar is doesn't required and the recognition is not permissible as per the Advocate Act, Welfare Scheme Act, and the place of practice rule. And this petition deserves to be dismissed.
कॉस्ट तो नहीं लगानी है.
Cost तो लगी जाएगी sir, dismiss.
इसीलिए तो
was
इनसे
a party to an application which was submitted to the state bar council.
ठीक है. अरे भाई,
My learned friend was a party to it. This is on record. He will not deny it. I never wanted to say.
हाँ, कहाँ है दस्तखत दिखाएं जरा. तो मैं बताऊंगा. उसमें सर उसमें देखिए 2006 लिखा हुआ है.
अरे वर्मा जी क्यों नाराज होते?
नाराज नहीं होते सर, ये लोग जबरदस्ती.
आपसे हमने एक
अगर आप बोल ही रहे हो तो फिर मैं बता भी देता हूँ.
अरे रुकिए अग्रवाल साहब,
If you want to-
अग्रवाल साहब रुकिए.
नहीं बता दीजिए आप क्या बताना चाहते हैं.
बता देता हूँ.
प्लीज
क्या बताना चाहते हैं.
हम जो भी बताना चाहते हैं बता भी देंगे.
सर,
बता देंगे भाई.
इन्हीं
ऐसी
को
क्या
बताना
बात
है.
एक मिनट.
ना, आवाज आप
बता देंगे
बता
ना.
दो.
बता देंगे
सबके आके बता दीजिए आप.
अरे
बता देते हैं अभी.
प्लीज मनोज जी
आ जाए बता
मेरी रिक्वेस्ट है आप सब
आ जाए बताएं सब.
प्लीज 4:10 पर लाइटर मूवमेंट पे कोर्ट को उठने दीजिए. कहाँ आप लोग इतना गंभीर बातें करने लगे? सुन ली आपकी बहस में सुनने को कभी मना नहीं किया. ये पर्सनल मत होइए प्लीज, मेरी रिक्वेस्ट है आपसे.
सर मैं आपको एक बात बताऊं,
हाँ.
इन चीजों में बिना पर्सनल हुए रहा नहीं जा सकता. हम कहते हैं बहुत बड़ी व्यापक बातें
हम
होती
पर्सनल
नहीं
नहीं
कहा
हो
जा
रहे, हम
सकता.
पर्सनल नहीं हो रहे.
नहीं सर, मैं बता रहा हूँ. अरे सर हमको तो वो टाइम भी याद है, अब आप वकील थे हमारे, आगे बैठते थे, कैंटीन फसली हमारे मेंबर थे.
तो थे ना, हमने कब मना किया?
क्या कोई बात नहीं कर रहे हैं उसकी.
तब तो-
संजय जी का ये हमारे साथी थे, हमारी कमेटी में थे.
आज भी है कमिटी. He has been the part throughout. He has been the
तो
part.
हम तो दोनों
He has been a member of the
थे.
executive committee in some or the other
I was
capacity.
member in both the bar associations.
He was the-
That cannot be
Lord, he
disqualification.
was a joint secretary of the.
I had been a member of both.
Lord, he is
I had been the
he was
president of
a
both the bars.
he was a joint secretary, founder committee of the association, my lord.
He's a respected member of the High Court.
103 लोग जिन्होंने कॉन्स्टिट्यूट किया था वहां पे, उसमें सबसे ये प्रमुख थे.
जनरल बॉडी में इनके रेजोल्यूशन है सर, इनके दस्तखत है. आपको वो नहीं कहना चाह रहे थे हम, लेकिन अब बात आई है तो हम कह भी देते हैं. ऐसा नहीं है.
ठीक है.
Much can be said, Lord.
भाई देखिए, ऐसा होता है जब डिफेक्शन होता है तो आदमी पहले तो मूल पार्टी का ही सदस्य रहता है, फिर डिफेक्ट कर जाता है.
नहीं आज भी है, आज भी हम. एंड कई एग्जीक्यूटिव बॉडी के इन डिफरेंट कैपेसिटीज ही हैज ऑलवेज बीन द मेंबर.
चलिए अच्छी बात है.
और जब हमने अप्लाई किया तो ही वाज अ पार्ट ऑफ द एग्जीक्यूटिव कमिटी.
चलिए,
इसमें लेटर पैड में इनका नाम देख लीजिए.
तो केस खत्म हो गया.
रेजोल्यूशन, जनरल बॉडी के रेजोल्यूशन में इनके दस्तखत है.
आपने आज
सर, मुझे ऐसा लग रहा है सर, मैंने बड़ी शानदार बहस कर दी है सर.
वर्मा जी एक मिनट रुक जाइए. वर्मा जी
और
एक मिनट
मेरी
रुक जाइए.
बहस से सर लोग बड़ा आहत हो गए सर. ऐसा लग रहा है.
आप नहीं हो गए. द एलिगेशन व्हिच ही वाज मेकिंग इट हैड बिकम नेसेसरी
एक बात
फॉर अस टू
आप एक
रिस्पोंड.
बात बताइए, आपने वर्मा जी को आज चाय पे बुलाया था नहीं बुलाया था?
जी
आज वर्मा जी को चाय पे बुलाया था नहीं बुलाया था?
सर, he is already a member of the bar association. He is already a member of the bar association.
I accept that.
He is already there.
आई एक काम करते हैं, चैम्बर में चाय पीते वहां बात करेंगे. चलिए नहीं, हाँ नहीं, आई एक्सेप्ट योर प्रपोजल. आप लोग आइए, आई ऑफर यू कप ऑफ टी. यस मोस्ट वेलकम.
चल.
लिखिएगा भाई, बुलाइएगा.
दो लाइन था बस, इनने जो नया बात बताई है.
दो लाइनें कविता सम्मेलन में सुनाई जाती है. कवि सम्मेलन में जाइए. सॉरी, अब नहीं.
बात में बताया ना
कवि सम्मेलन में.
सर कविता नहीं है सर. इन्होंने जो एक जजमेंट बताया सुप्रीम कोर्ट का, वो ऑथराइज बॉडी थी कोर्ट के साथ.
अरे भाई ठीक है,
अनऑथराइज.
ठीक चलिए नेक्स्ट.
ये में बीच में बोलने का क्या मतलब है सर?
अरे
हमारे पास काफी ज्यादा नहीं है, इसका मतलब हम चुपचाप रहे और सुनते रहेंगे.
नहीं, आदमी से कुछ नहीं होता है.
ये हमेशा ही बीच.
He is so powerful, sir. सब हिला के रखा सबको. He is so powerful. We acknowledge his power.
बस अब हो गया. नाउ ही हैज एक्नॉलेज्ड योर पावर. बैठिए आप आराम
We
से.
again acknowledge his power, Lord. सबको हिला के रखा.
बैठिए आराम से बैठिए. वर्मा जी लिखिएगा. WP 5193 of 2016. Shri Satish Verma, continuing from his yesterday's argument, submits that judgment of Supreme Court in BD Kaushik says that all the lawyers should be under one umbrella. Full stop. Referring to para 18 of the High Court Office Memorandum dated 19/12/2016, signed by the then Registrar General Shri Manohar Mamtani, he submits that the principle is one person, one chamber, one court complex. Next para. It is submitted that the decision of Supreme Court in Saira Banu is 2017 9 SCC 1. Next. He further submits that OBC Welfare Advocates Welfare Association has also applied for a space before Honorable the Chief Justice, and if fragmentation of bars is allowed to be carried out, then several fragments will stand up to claim spaces which may cause a problem for the High Court in future. Next para. Shri B. N. Mishra, learned counsel for the High Court, in his turn submits that respondent number 3 is a licensee, as there are no rules for allotment of a licensed premises. Therefore, Chief Justice in his discretion can allot spaces according to his discretion and wisdom. Reliance is placed on judgment of Supreme Court in नाम देख लेना 2005 का एक SCC 590 है क्या दीजिएगा.
That judgment is in the part of PIL notes. It is not in the point of power of the Chief Justice.
इसको next para में लिखिएगा. It submits placing reliance on this judgment in Dattaraj Nathuji Thaware versus State of Maharashtra and others 2005 का एक SCC 590. It is submitted that petitioner has no right to file PIL. Reliance is placed on para 20 of the said judgment to point out that Supreme Court was magnanimous enough not to impose further cost on the petitioner, as it was already imposed by the High Court while dismissing the petition.
That this judgment is on the point, Lord, when a member of the legal fraternity, he invokes the writ jurisdiction.
चलिए लिखिएगा. He submits that this judgment is on the point that when a member of a legal fraternity files a writ petition, then that person has
For oblique motives. For oblique motives.
for oblique motives, then that person has no locus. Next para. This judgment per se is not applicable to the facts and circumstances of the present case, in as much as it has come on record and noted by the Honorable Supreme Court that in that case the counsel was caught red-handed blackmailing respondents 6 and 7 in respect thereof and accepting blackmailing money. Full stop. In the present case, there are no such allegations either on the petitioner or his counsel. Therefore, reliance of the High Court on the judgment without applying the facts and situations of the present case is out of place. Therefore, reliance on this judgment is hereby rejected. Next para. Shri Anil Khare, learned counsel for the respondent High Court Advocates Bar Association, submits that allotment is not malified. He places reliance on paragraph 49 and 80 of BD Kaushik's judgment. Next para. Shri Sanjay Agarwal, learned senior advocate, to supplement the submissions made by Shri Anil Khare, senior advocate, submits that Petitioner Bar Association was registered under the MP Society Registrikaran Adhiniyam 1973. Its bar room was inaugurated on 26/9/2008 by the then Chief Justice. Then library was inaugurated on 14/11/2009 by the then Chief Justice of India in presence of other Supreme Court and High Court judges. Then on 8/4/2011, conference room was inaugurated by the then administrative judge. On 30/4/2016, e-library was inaugurated by the then Chief Justice. And in 2017, additional adjoining space was allotted to the Bar Association by the then Honorable Chief Justice Shri Hemant Gupta, while order dated 19th July 2017. In support of this contention, order dated 19th July 2017 is placed on record, which is taken on record. This order reads, within inverted commas, Honorable the Chief Justice is pleased to allot the room in the first floor of the old administrative block presently occupied by the Supreme Court section of the High Court Advocates Bar Association, Jabalpur. Next paragraph. It is also pointed out that on 11/12/2017, new bar room was inaugurated by the then Chief Minister and the Honorable Chief Justice in presence of other judges. Then an exhaustive list of facilities which are available in the Bar Association, in the space allotted to the Bar Association, have been detailed out, and it is pointed out that lakhs and lakhs of rupees have been spent on creation of those facilities, and petitioners and the respondent association cannot be uprooted overnight as they are in existence since 2006. Next para. It is also pointed out that there is no need for sanction of Bar Council, and High Court Advocates Bar Association can exist as an association without recognition from the Bar Council. There is no need to subject decisions of the Honorable Chief Justice to the judicial review, and therefore the decision of the Chief Justice to allot space cannot be subject of judicial review. Full stop. Then a list of lectures which have been organized by the association from 14/11/2009 to 2/12/2017 have been detailed out, and thereafter it is pointed out that the Petitioner Bar Association is officially invited in all the official functions recognized by the High Court. Full stop. It is pointed out that they are part of High Court Rules Committee, wherein name of the President of High Court Advocates Bar Association Jabalpur is mentioned at serial number 9. Similarly, name of the President of the Association is mentioned in committee number 33, that is Apex Committee for Redressal of Grievances of Litigants and Members of Bar Association, as per scheme notified by High Court Order number, in number note कर लेना, पेज A2 में पेज 8 पर है, इतना. Next para. Reliance is placed on the judgment of Supreme Court Bar Association and others versus B.D. Kaushik on para 28, 49 and 80. Full stop. Reliance is also placed on the judgment of High Court of Madras in WP number 4418 of 2011, the Gobi Chettipalayam Association versus Bar Council of Tamil Nadu, and order of Madras High Court in WP 9752 of 2015, Madras High Court Bar Association versus the Secretary Bar Council of Tamil Nadu. Full stop. Reliance is also placed on the judgment of Supreme Court in Supreme Court Bar Association versus Ministry of Urban Development and others, 2023 live law within bracket SC bracket close 236, wherein it is mentioned that matters of allotment of spaces to the bar associations should be left best to the administrative discretion and on the administrative side rather than being dealt under Article 32 of the Constitution. Next para. It is also pointed out that the petitioner Shri Amit Patel had put in only 11 appearances in 8 years from 2016 to 2024. Therefore, he cannot be said to be a public spirited person entitled to file a public interest litigation. Next para. In WP 7551, नहीं सॉरी इसी में कर दीजिएगा, श्री WP 7551/16, referring to Section 22 of the Society Registrikaran Adhiniyam 1973. Attention is drawn to page 10, 11 and 12 of the rejoinder filed by IA number 1363 of 24 to point out that petition has been filed by a duly authorized person. Reliance is also, it is also submitted that the judgment rendered in case of Swachhata Grisang Nivas cited by the Bar Council has no application to the facts of the case. Full stop. It is also submitted that Section 2 within bracket A of the 1982 Act deals with definition of advocate, and petitioner is entitled to be an advocates bar association without any recognition from the Bar Council of Madhya Pradesh. Full stop. It is submitted that Wide Annexure P12, an amendment application filed in the year 2023, order of the Bar Council dated 5/2/2018 was challenged, but thereafter Bar Council has not filed any reply to the amended petition. Full stop. SHRI provisions contained in Rule 4 within bracket G, 6.1 and 6.3 of Rules of 2015 are exhaustively read over. Next para. Shri Vipin Yadav, appearing for the State Bar Council of Madhya Pradesh, fairly submits that he does not wish to file reply to the amended petition. He submits that Annexure P12 was added by way of amendment belatedly. Petitioners have neither assailed nor challenged the reasoning given by the Bar Council in Annexure P12. Therefore, there is no need to file any reply. Full stop. He further submits that judgment cited by the on behalf of the High Court Advocates Bar Association in Gobi Chettipalayam Association has no application to the facts of the present case, in as much as in that case certain members were expelled from the parent body and they were not taken back, which forced them to form another association, whereas that is not the case here. It is submitted that the members of the High Court Advocates Bar Association are either members of the High Court Bar Association or of the District Bar Association. Therefore, in terms of the rules of 2015, there is no hindrance in their casting votes or getting benefits of the welfare schemes handed over by the Bar Council or under the auspices of the Bar Council of Madhya Pradesh. Next para. It is Shri Sanjay Verma submits that this petition is filed for taking benefit of Adhivaktya Kalyan Nidhi Adhiniyam, but from the interim relief, it is evident that the petition was filed not for this, but in the garb of the provisions which were brought into effect by the rules of 2015, recognition rules of 2015, as the members are of the High Court Advocates Bar Association are getting recognition before the Bar Council either through the representation of High Court Bar Association or the District Bar Association. That ground is not available to claim separate recognition. It is also submitted that fragmentation of bar is to weaken the bar associations, and the successive chief justices can play this aspect so to weaken the unity of the bar, as has been mentioned in the mentioned in Annexure R33 filed by the High Court Bar Association along with their reply wide IA 277 of 2024. Full stop. Reading specifically from the representation made by the then President of the High Court Bar Association, Shri Adarsh Muni Trivedi, it is pointed out that in para 2, sorry. In para 2, it is mentioned as under. इसको हिंदी में बोलूं धीरे धीरे, लिख लेना। ये इनके जवाब का पेज नंबर 20 की टाइप्ड कॉपी है। उसमें माननीय उच्च न्यायालय और खत्म हो रहा है, न्यायपालिका को बार की एकता और एकरूपता को विखंडित करने का अवसर देगी। Reading from this representation, it is submitted that though there is no bar on creation of parallel bar associations will be fraught with several consequences which cannot be appreciated without having vision for a larger tomorrow, a better tomorrow. Next para. SHRI. ठीक है, बस मैटर हर्ड रिजर्व दोनों मैटर्स कर लीजिए। उसमें वो उनका हाई कोर्ट का जो मैंने वो लिखा दिया था ना, वो नॉट एप्लीकेबल, वो रिश्वत लेते पकड़े गए, तो उसको अभी हटा दीजिएगा। हाँ, सब लिख के दे दीजिएगा जी।
So we will assemble in the same combination on 20th for the last electricity matter. 20 तारीख को रखा।
इलेक्ट्रिसिटी में तो आपको करंट ही देना है, हमको एक जगह
हमको पैसा लेके तो उनको देना है, कैसे करंट मिलता रहे। मुकेश जी करंट देते रहते हैं हम लोग को। 1,50,00,000 हो गया, 2 करोड़,
तो आपके एसोसिएट हैं
लेकिन करंट देते।
आइए आइए।
यस,
सिंगल मैच का बैटर बचा है, तो कल टॉप अप कर लीजिएगा।
हाँ, वो मैं पहले बता रहा था ना, मैं एक ही ऑर्डर में था ना। डाउन करा कल हुआ है ना। भैया आप सामने क्या चल रहा है? ये हिंदी वाला कहाँ है? इसको स्क्रॉल कैसे करते हैं?